digital eye exam is why. Eyeglasses with prescription lenses starting at $99. Lens Crafters is why. Book an eye exam today.
Ready?
Carla is living with metastatic breast cancer, which is breast cancer that has spread to other parts of her body. She's also taking prescription Ibrance with an aromatase inhibitor, which is for postmenopausal women with hormone receptor positive, HER2 negative metastatic breast cancer as the first hormonal-based therapy. Ibrance plus letrozole was significantly more effective at delaying disease progression versus letrozole. Patients taking Ibrance can develop low white blood cell counts, which may cause serious infections that can lead to death. Before taking Ibrance, tell your doctor if you have fever, chills, or other signs of infection, liver or kidney problems, are pregnant, breastfeeding, or plan to become pregnant. Common side effects include low red blood cell and low platelet counts, infections, tiredness, nausea, sore mouth, abnormalities in liver blood tests, diarrhea, hair thinning or loss, vomiting, rash, and loss of appetite. Carla calls it her new normal because a lot has changed, but a lot hasn't. Ask your doctor about Ibrance, the #1 prescribed FDA-approved oral combination treatment for HR-positive, HER2-negative MBC.
Feel the clarity of non-drowsy children's Claritin Allergy Relief, the #1 pediatrician-recommended non-drowsy brand. Because to a kid, a grassy hill is irresistible. Children's Claritin. Feel the clarity and live Claritin Clear.
When tough pain strikes, don't tough it out. Try this first. Salonpas Patch Large. They're twice the size as before with the power to target large pain areas. Make Salonpas your first choice for tough pain relief.
It's nice to know you can be all in, even when your bladder isn't. Poise liners have a clean and fresh layer and stay 5 times drier, so you can stay you and stay amazing. Poise, the #1 brand for light bladder leaks.
Family taco night is a heartburn night you can plan for, but surprise pizza at the office means heartburn you didn't expect. Zantac works when you need it. It relieves or prevents heartburn in as little as 30 minutes and lasts up to 12 hours. Zantac. Eat your way, treat your way.
It's not just a race. You're being chased by these elite athletes.
I'm the first African-American professional triathlete. I'm fearless.
I'm addicted to pushing myself. I'm addicted to pain.
Pound for pound, the strongest athlete. My greatest advantage is I'm just devilishly handsome.
$1 Million Mile premieres CBS tonight after Survivor.
It's the ACM Awards with performances by Little Big Town, Maren Morris, Thomas Rhett, Chris Stapleton, and Brothers Osborne. Live CBS Sunday, April 7th.
He said yes? That's unbelievable.
I told you I'd do it.
When are they moving in?
Tomorrow.
Tomorrow?
Yeah.
Wow. You're really good. I'm so sorry I pushed you away about this for so long. Thank you for not giving up on me. Or my dad.
Of course, of course. you can't quit. The work you were doing was important, and you loved it there.
I don't want to work for someone who treats you the way that they did.
Paul had every right to do what he did.
So did I. You're missing the point. Stop stepping all over my grand gesture.
Okay. I will take your grand gesture and raise you one. It's time I took you out on a proper date.
Hey, what's with the phone rage?
Just something I have to handle for work.
Uh-huh. I just had a brief talk with Summer.
How's she doing?
She's tired. I hope you don't mind. I told her I knew about the surgery. I couldn't bring myself to lie to her.
It's fine. How'd she react?
Pretty defensive at first, and then she was determined to convince me that you two were meant to be. I know this doesn't go both ways, but that girl is pretty crazy in love with you.
I know.
So what are you going to do?
I have no idea.
Yeah, this is a tough one. But seeing her so weak and swooning over you, I really felt for her. The idea of taking one of her organs and then pushing her aside seems kind of wrong.
you're feeling more burden, call Express Home Buyers and sell that house in less time than it will take to clean it.
The only thing that I would do differently, the only thing, I should have called Express Home Buyers sooner.
DMV Soundcheck every Friday morning on WUSA 9.
The Code, series premiere, CBS April 9th after NCIS.
I saw a couple of her dresses in the boutique, and then I asked around until I found her.
You were that impressed?
She's up and coming. She's not polished, not typically Forrester, but we are attracting a younger demographic thanks to Stephanie and Hope. And Sally's leaving. There's a spot on the design team. So I'm going to have Donna make a packet for you to review.
Well, I'm looking at a few portfolios myself, so is that it? Anything else?
Well, I was thinking about the rose gold collection we had a few years ago. I was thinking of bringing it back with some bigger, chunkier pieces if nobody objects.
Why don't you show me what you have and we'll go from there.
I'll get on it later this afternoon. Right now I have a lunch date with Wyatt.
Oh, one more thing. Sally's in the building. She wanted a second to say hello to all of us before she leaves. Pam, send her in? Yeah. So, Sally, you all wrapped up?
Close? Yes. I just wanted to take a moment to thank you all for this opportunity you've given me at Forrester.
Janie? Jenny? Jenny? What was her name? I gotta write these things down. Janie, you there? Okay. Yeah. Wyatt Spencer's office. Who's this? Oh, no, he's not here right now at the moment. Sorry. Oh, really? We sound alike. That's interesting because I haven't met him yet. I'm a temp. Yeah, I'll let him know you called. Thanks. Stop. Oh, for the love of God. Seriously? Oh! Oh, finally. I really need some help with... Hi.
What do you need help with? Leaving here is one of the most bittersweet things I think I've ever had to do. I will forever be grateful for the chance that you took on me. I have had the most amazing time here at Forrester. I could easily see my entire career playing out within these walls. Well, it looks like the universe has other plans for you.
And we couldn't be happier. You're a wonderful designer. You never should have lost your fashion house to begin with.
Still can't believe Bill is making it right, though.
But he should, so good for him, I guess. Yeah, well, it's all thanks to Wyatt. Designing my own line has always been my dream. But I couldn't leave without telling you guys how much it meant to be here.
I think you're making a mistake.
Whoa, 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 whoa. Hey.
They ran right past me.
Yeah, sorry. We heard Sally was in here.
There's something you need to know right away. Where did you guys get those?
Yeah, Zoe and I saw them in the sewing room.
And I was delivering some design notes while they were there. But those are concepts for my new athletic wear line.
Well,
I mean, they're just prototypes.
That's why we had to find you. The most amazing thing just happened.
something I need to tell you.
Tax reform is complicated, kind of like this stuff. Tax reform with H&R Block? Much better. No one knows tax reform better than Block. In person or online, Block has your back.
My new Beneful Superfood Blend has me feeling super healthy with salmon, cranberries. Oh, but we are not done yet. Here comes Superfood Wet with beef, salmon, and pumpkin. It's like a superfood sundae on a Monday.
New Beneful Superfood Blend dry and wet recipes. Gentle means everything. So we improved everything. We used 50% fewer ingredients, added one-handed pumps, and beat the top safety standards. Johnson's. Choose gentle.
When I created Nor Selects, I looked for real ingredients, for real taste. Absolutely no artificial flavors or preservatives. Nor Selects. Real ingredients for real taste.
You know you can tell me anything, right? So what's going on?
Shouldn't you get all his phones that are on hold?
What phones?
Oh, so if you don't acknowledge them, then they don't exist?
Yeah, exactly. What did you want to tell me? I need to know now.
How wonderful it's been to get to hang out with you again.
It goes both ways.
I couldn't be happier for this life that you found. And if leaving me is what you had to do to get all of this, then I can make peace with that.
Wow. That's generous, considering the way that I just left you.
No, I mean, you explained it all, and you know, if you hadn't left Vegas, you never would have found your father.
Mm-hmm.
You never would have had all this success. I mean, it really does blow me away. From where you came to all of this building, this office, this beach house that you have, and your name plastered all over the walls. It's crazy.
Well, I can't take credit for all of that. You know, Dad built this thing, you know what I mean? I just kind of walked into it. It's hard to wrap my head around sometimes. Not only did my father accept me, he embraced me into this world and just Sorry, I didn't mean to be so insensitive.
What do you mean?
Well, fathers. I haven't forgotten that you know nothing about yours, unless that's changed.
No, I would have told you. But please don't censor yourself about that. We don't all win the dad lottery.
I don't know about that. I mean, it hasn't always been easy between Dad and me. We don't see eye to eye on everything. Sometimes fundamental stuff, how to live your life type stuff, but he's changing, and I've seen a lot of positive results. I'm feeling pretty good about the future. Being back here at Spencer, and obviously Sally now being on board and everything.
You're really supportive of her, aren't you?
Well, yeah. Sally's an amazing woman and an incredible designer. She deserves everything coming her way, especially this reboot of her fashion house here at Spencer.
Zoe has a photo shoot, otherwise she'd be here to tell you.
Tell us what?
Okay, so Zoe, Tiffany, and I are having lunch on Melrose when all of a sudden this huge crowd approaches.
It was crazy.
Couldn't tell who it was at first because a lot of security, but then she appeared.
Wait a second, is that?
Uh-huh. Oh, wow.
Hmm.
Huh. Are you kidding me?
I know who this is.
Yeah.
I mean, we took a selfie with her because we didn't think anybody would believe us without it, but the real news... Okay, so the reason she came up to us was...
She loved the designs. Your designs. Shut up.
For real. Especially when she asked where they were from, and we said Forrester. She's about to shoot some huge music video, and she wants to feature your athletic line on herself and her dancers.
What? This is huge. You can't buy that brand awareness.
No, especially since all her followers want to dress like her. I mean, she's going to generate insane sales.
Yeah, we told her the clothes weren't in production yet.
That made her want them even more.
She wants you to reach out to her stylist.
take Neulasta if you're allergic to it, or Neupogen, filgrastim. An incomplete dose could increase infection risk. Ruptured spleen, sometimes fatal, as well as serious lung problems, allergic reactions, kidney injuries, and capillary leak syndrome have occurred. Report abdominal or shoulder tip pain, trouble breathing, or allergic reactions to your doctor right away. In patients with sickle cell disorders, serious, sometimes fatal crises can occur. The most common side effect is bone and muscle ache.
Ask your doctor about Neulasta Onpro. Pay no more than $5 per dose with copay card.
Family taco night is a heartburn night you can plan for, but surprise pizza at the office means heartburn you didn't expect. Zantac works when you need it. It relieves or prevents heartburn in as little as 30 minutes and lasts up to 12 hours. Zantac. Eat your way, treat your way.
Before I head out the door, it's what I'm looking for. Today's a daisy, I see the difference in me. Today's a daisy for college
This Thursday through Sunday only, gather your crew for the JCPenney Friends and Family Sale. Everyone saves an extra 25%. Check your JCPenney app wallet for your coupon. Shop women's tops, men's polos, and sheet sets. Get great deals for all. JCPenney.
I'm 53, but in my mind, I'm still 35. That's why I take OsteoBiflex to keep me moving the way I was made to. It nourishes and strengthens my joints for the long term. OsteoBiflex, because I'm made to move.
You said you'd rather sniff dirty socks than clean the bathroom? That's nuts! With scrubbing bubbles, cleaning doesn't have to stink. It gets rid of tough soap scum, and it smells amazing. It's cleaning reinvented.
S.C. Johnson.
I am totally blind, and Non-24 can throw my days and nights out of sync, keeping me from the things I love to do. Talk to your doctor and call 844-214-2424.
The Academy of Country Music Awards. Who will win? Female Artist of the Year. Miranda Lambert, Ashley McBryde, Maren Morris, Casey Musgraves, or Carrie Underwood. Find out live at the ACM Awards. Sunday, April 7th, only CBS.
Additional sponsorship provided by
Even our pets know to go directly to PetMeds.com to save 30% on all the medications we carry. So go directly to PetMeds.com now.
It's refreshing, you know, seeing a guy so absolutely crazy about his girlfriend.
Well, Sally checks all the boxes for me. She's witty, smart, talented. She laughs at my corny jokes. Is not so bad on the eyes either.
How long have you been together?
Who's counting? Just living in the moment. Hoping it lasts.
You don't have any plans for the future?
Just taking it day by day.
Oh, well, it must be a great relationship if you can live together and work together. That's great. You guys are very lucky.
Trust me, we know. We are not taking for granted what we have together.
So how did Sally get this job here at Spencer? Or do I even have to ask?
I might have had a little hand in then. But she deserves this opportunity. And trust me, she's going to take full advantage of it.
All right, Quinn's off to her lunch, but I know she's very anxious to hear what your decision is, and so am I.
I know you're already halfway out the door, and I know that there's an extra bonus waiting for you at Spencer because Wyatt's over there.
True. Yes, but my decision was based off me being able to run my own fashion house.
I know that, and I get that. You want to have your own version of Spectra, but it's going to be under the Spencer name, and I just think you'd be better off staying here. You've already proven yourself to this company, and if this crazy little dance that Tiffany and Xander were doing is any indication, then you will have any success that you ever dreamed of right here under the Forrester label.
I don't know what to say.
Don't say anything. I'm in the middle of pitching something right now. Listen, hey, my dad, Brooke, and I, we've been designers for a very long time. Spencer hasn't. Starting a fashion house is a very, very complicated thing to do.
Many have tried. Many have failed.
And yes, you come with something special. You come with a Spectra name. But Bill is not going to let you use it. It's all going to be Spencer Fashions. And the industry doesn't care about that at all. It's going to be years before this company makes a dent. So yeah, you can go over there and you can sit and wait and hopefully you get a shot. Or you can stay here. Forrester Creations. I mean,
and we would hate to lose that.
Think about the offer.
I will. I have to discuss it with Wyatt.
Of course, yes, you should do that.
Don't you have an assistant?
Used to. I mean, it was Dad's mostly, but he shared her with me. Unfortunately, the scarily efficient Allison has moved on to better opportunities, leaving us to deal with temps, which, as you can see, has been less than ideal.
Well, I should probably get going. I'm obviously keeping you from something important.
Well, just know that my door is always open for you.
It's very sweet.
Promise me that you're not going to go anywhere. You'll try to make a life here in LA. I mean, I'll help you any way that I can.
Where is Allison?
Flo? Flo Fulton? Oh my god! Oh, so good to see you! Hi, Quinn. Hi.
Why didn't you tell me Flo was in town?
With moderate to severe Crohn's disease, I was there. Just not always where I needed to be.
Is she all right?
I hope so. So I talked to my doctor about Humira. I learned Humira is for people who still have symptoms of Crohn's disease after trying other medications. And the majority of people on Humira saw significant symptom relief, and many achieved remission in as little as 4 weeks.
Humira can lower your ability to fight infections, including tuberculosis. Serious, sometimes fatal infections and cancers, including lymphoma, have happened, as have blood, liver, and nervous system problems, serious allergic reactions, and new or worsening heart failure. Before treatment, get tested for TB. Tell your doctor if you've been to areas where certain fungal infections are common, and if you've had TB, hepatitis B, are prone to infections, or have flu-like symptoms or sores. Don't start Humira if you have an infection.
Be there for you and them. Ask your gastroenterologist about Humira. With Humira, remission is possible.
For singing, definitely dry mouth has been a problem for me. I'm also on a lot of medications that dry my mouth. I just drank tons of water all the time. It was never enough. I wasn't sure I was going to be able to continue singing. I saw my dentist. He suggested biotin. It feels refreshing. My mouth felt more lubricated. I used biotin rinse twice a day, and then I used the spray throughout the day. It actually saved my career in a way. Biotin really did make a difference. Oh, Sarah, can you remind me to give Baxter's flea and tick treatment next week?
Instead of trying to remember the monthly flea and tick treatment, ask your vet for
Brevecto, the only one that lasts up to 12 weeks with just one tasty chew. Do you remember where we parked the car?
Brevecto, only from your vet.
Am I willing to pay the price for loving you? You'll make my morning, but ruin my day.
Complicated relationship with milk? Pour on the Lactaid, 100% real milk, just without that annoying lactose.
That's good.
Survivor tonight. Brace yourself.
Wait,
For a showdown. One of these 6 is about to earn their way back into the game.
Oh, no.
Yo! A can't miss Survivor, CBS tonight.
No cover.
You've been authorized to eliminate Zaman.
No protection.
All right, boys, let's get to work.
And totally exposed.
You have enemy moving on your position. You gotta move!
They're as good as dead.
New SEAL Team, CBS tonight.
So you think Sally will stay?
You made a good pitch, son.
It's not about the pitch, Dad. I think this is what's best for Sally. And yes, starting a new fashion house could be exciting, but Bill doesn't know what he's doing.
It may be a little more complicated, though, than just whichever deal is the better one. Hearts are involved here. If Sally turns down the opportunity that Wyatt arranged for cause a big problem in their relationship.
It's business. Wyatt understands that.
Well, I get what Eric's saying. If Wyatt is expecting her to come over to Spencer and she doesn't go.
Could cause problems. It really could. Look, I want what's best for this company, too. But Wyatt and Sally are really good together. I'd hate for anything to come between them.
It is so great to see you too, Quinn.
Believe this. You have been keeping quite a secret. Should I be on the lookout for more?
It never came up.
Yeah, well, how would it come up if you didn't bring it up? So do you live in LA now?
I'm just visiting now.
How long have you been here?
A couple of months.
Yeah, and have you and Wyatt been in touch this whole time?
No. We just recently ran into each other.
Literally.
This is incredible. Look at you. Flo Fulton, you are just a full-grown woman. You are just as beautiful as ever. You know what? You're more beautiful than ever.
Oh, and you look incredible yourself.
Well, thank you. My marriage agrees with me. How's your mom?
She's good.
I haven't seen her since we left Las Vegas. We were so close.
I know that she missed your friendship a lot.
Will you please give her my love? So, what about you? I mean, what brings you to LA? Where are you staying? And do you love LA enough to make it a permanent visit?
Okay, Mom, can we not put the interrogation?
What? No, come on. No. I'm so excited. I mean, Flo, you have always had such a special place in my heart. I hope you and Wyatt have been able to set things straight.
We have, yeah.
Yeah? You know why we had to leave Las Vegas the way we did. He hated it. Really, he did. He hated leaving you. He was really mad at me. He froze me out for months and months because he loved you
Okay, Mom,
so
can we
much.
stop,
What?
please?
No, you know
Yeah?
that's true. Come on. You always used to talk about how perfect Flo was, how perfect you were as a couple, and that you were convinced that you guys would end up getting married someday if fate hadn't intervened.
Fate?
A
Oh,
little bit.
okay. I'd go with more like shady business.
No. Either way, after all these years and all his other relationships, there has never been anyone more suited for you than Flo.
Hello?
Hey, Clutzy me. I didn't mean to interrupt. I'll come back.
No way.
I should just get going.
No.
Look, Mom, you know Sally and I have been seeing each other for several months now. We've been living together because we care about each other. Now, I don't know how you feel about our relationship, but I'd like to think that it's supportive. And you see how happy Sally makes me. All right? Now, maybe you didn't mean to be hurtful, and maybe you didn't know that the things that you were saying were completely disrespectful to my relationship with Sally. So I'm going to need you to apologize to her. I mean it, Mom. Apologize. Now.
People are managing type 2 diabetes with food, family, and the pill that starts with F. Farxiga, along with diet and exercise, helps lower A1C in adults with type 2 diabetes. Although it's not for weight loss, it may help you lose weight.
Do not take if allergic to Farxiga. Symptoms of a serious allergic reaction include rash, swelling, difficulty breathing or swallowing. Stop taking and seek medical help right away. Tell your doctor right away if you have red color in urine, or pain while you urinate, or a genital area infection, since a rare but serious genital infection may be life-threatening. Do not take Farxiga if you have severe kidney problems, are on dialysis, or have bladder cancer. Other serious side effects include dehydration, genital yeast and bacterial infections in women and men, urinary tract infections, low blood sugar, and sudden kidney problems. Stop taking Farxiga and call your doctor right away if you have symptoms of ketoacidosis, which is serious and may lead to death.
Ask your doctor about Farxiga and visit farxiga.com for savings. If you can't afford your medication, AstraZeneca may be able to help.
Fit Me Foundation from Maybelline, New York. Fit skin tone and texture in 2 finishes. Matte and poreless, and dewy and smooth. 64 fits. Fit Me Foundation, only from Maybelline, New York.
When I created Nor Select,
use heavy, overwhelming scents. Introducing Febreze One, a new range of innovative air fresheners with no heavy perfumes that you can feel good about using in your home to deliver a light, natural-smelling freshness. Febreze One neutralizes stale, stuffy odors and releases a subtle hint of fragrance like bamboo or lemongrass ginger. To eliminate odors with no heavy perfumes, try new Febreze One. Brand Power, helping you buy better.
It's not just a race. You're being chased by these elite athletes.
I'm the first African-American professional triathlete. I'm fearless.
I'm addicted to pushing myself. I'm addicted to pain.
Pound for pound, the strongest athlete. My greatest advantage is I'm just devilishly handsome.
$1 Million Mile premieres CBS tonight after Survivor.
It's a can't-miss week. She's causing trouble.
I'm not gonna let you blackmail me.
Be prepared for the consequences.
He's taking charge.
You helped 3 prisoners escape, turning your badge.
And they'll all get rocked by a massive twist.
My God.
The Young and the Restless, weekdays, CBS Daytime.
In DC, great weather days are powered by Sheehy.
With Persona Doctors, you'll want to eat less, so you'll lose more. We prescribe powerful medications that curb your appetite, burn fat, boost your energy with natural hormones that keep the weight off. It'll change your life, guaranteed.
Guaranteed results. You have nothing to lose but the weight.
You've been chosen, and everyone is watching. You've been anticipating this moment since the last time you came to Uncle Julio's. Experience the unforgettable moment of smashing a chocolate piñata. Make fresh memories only at Uncle Julio's.
Is your house less than perfect? I'm Dan from Market Pro Home Buyers, and we want to buy your home.
Market Pro Home Buyers gave us a fair offer and truly helped my family.
Call us today at 301-799-7355.
At Persona Doctors, we help people lose weight and change lives. We prescribe safe, powerful medications that curb your appetite, burn fat, boost your energy, with natural hormones that keep the weight off. Guaranteed.
Book now and get our most powerful fat burner shot free.
6 castaways battle for one spot back in the game. Go! New Survivor, CBS tonight.
It's Wednesday, March 27th, and the talk is live. Chicago police, the mayor, and the prosecutor who dropped the charges against Jussie Smollett say he's guilty of staging a hoax and is a liar. Meanwhile, Jussie insists he's an innocent man and wants to return to work. But new reports say the cast and crew of Empire are deeply divided over Jussie returning to the set. See what happens when spring breakers turn the tables on an attempted robber at a Florida gas station. The video's gone viral. Icon Diana Ross feeling endless love on her 75th birthday. We'll have highlights from her exclusive bash, including performances by Beyoncé and Stevie Wonder, and a star-studded guest list. Today's show favorite Kathy Lee Gifford reveals she's still friends with disgraced former anchor Matt Lauer. Fixer-upper star Joanna Gaines says giving birth again at 40 had an unexpected upside. We'll tell you what it is. Then, from Gossip Girl to a grown-up with hilarious problems in the new sitcom Single Parents, the lovely Leighton Meester is here. Plus, from the Hallmark movie True Love Blooms, the delightful Sarah Rue. So, let's start talking. Jussie Smollett's 16 charges being dropped. The same day the charges against him were dismissed in the hate crime hoax case, the Chicago Mayor Police Superintendent and state prosecutor still insist they believe he's guilty. Here's the latest from CBS This Morning and GMA.
Since we haven't started, we could have a little music to get us going in honor of the occasion. Is it going to work? Work, work. That's enough, I guess. Pardon me, miss. You get some more folks coming?
I hope so.
Yeah, me too. How you doing? Good? Good. Where's our team? Democratic team, come. Put on an APB. The boot. Does she report called the boot? The top of the boot. If we go ahead and start, can you promise you won't make a motion to adjourn? I think we should give people, we're going to give them a few more minutes. Well, we were going to wait for about 4 more members, but the chairman counts as 4. So we're starting. Thank you, each of you, for coming here. The Committee on the Judiciary, Subcommittee of the Constitution, Civil Rights, and Civil Liberties will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. I welcome everyone to today's hearing on examining the constitutional role of the pardon power, especially the young students from Collegiate School. I will now recognize myself for an opening statement. The fundamental purpose of the pardon power is to ensure fairness and proportionality in our criminal justice system and to provide a check against miscarriages of justice. In essence, mercy and justice. In light of this purpose, we examine today questions about the potential constitutional limits of that power, particularly given how President Donald Trump has used or has implicitly suggested that he may use this power. Article 2, Section 2 of the Constitution outlines the powers and responsibilities of the executive branch and provides, among other things, the President, quote, shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment, unquote. The Constitution only places 2 textual constraints on the pardon power, limiting its reach to federal offenses only and barring its use in the case of impeachment. Nonetheless, the exercise of the pardon power under certain circumstances raises a number of unanswered constitutional and legal questions. Ergo, this hearing. Chief among these questions are 1, whether the President may pardon him or herself. 2, whether other provisions of the Constitution, while not an explicit restraint on the pardon power, nonetheless place boundaries on its exercise. And 3, whether issuing a pardon or offering to issue a pardon can implicate criminal statutes prohibiting obstruction of justice or bribery. A discussion of these questions which during normal times may have been mostly on an only academic level, has taken on greater importance during this Trump presidency. For example, President Trump, in the midst of the now concluded special counsel investigation, boldly asserted in a tweet, "I have the absolute right to capitalize, pardon myself," unquote. I would note that today's hearing was scheduled before Attorney General William Barr transmitted his letter characterizing the principal findings of Special Counsel Robert Mueller and his interpretations thereof. The constitutional and legal issues that this hearing will explore, however, may be profoundly relevant to evaluating one of the counsel's questions of special counsel's, one of his investigations. Did President Trump abuse the powers of his office, including the pardon power, to obstruct this and related investigations into his conduct and the conduct of his associates, and might he do so in similar circumstances in the future? I am sure my friends on the other side will argue that Attorney General Barr's recent letter, well, I'm not sure they will. Some of them will say it totally exonerated President Trump. Some of them will realize that it didn't say that. They will say there was no collusion, and there apparently was concurrence with Mr. Mueller. There was no collusion. But I would caution my colleagues against relying solely on Mr. Barr's summary and to avoid making such a sweeping pronouncement before seeing the actual report written by Special Counsel Mueller. Mr. Barr only had a few hours to look at the report. Mr. Mueller had 22 months to prepare it and study it, and it was part of his work, and he said that it did not exonerate the president. The truth is that Mr. Barr's letter raised more questions than it answered. Mr. Barr's letter revealed Special Counsel Mueller pointedly noted that it did not exonerate the president for obstruction of justice. In fact, according to Mr. Barr, the Special Counsel's report set out, quote, evidence on both sides of the question, unquote, which would include evidence that supports the conclusion that the president obstructed justice. This is why it's imperative that Mr. Barr provide the Special Counsel's report in its entirety to Congress, along with any underlying evidence. That's pretty much what's happened in other reports of counsels. They have not drawn conclusions. They've left it to the Congress to do that. Only in this case was there a defensive back on the field who jumped in and intercepted the ball before it was passed to Congress. Frankly, whether or not President Trump colluded with the Russian government is irrelevant to the question of whether he abused the powers of his office to obstruct the Special Counsel's investigation. Special Counsel Mueller had a duty to provide the full picture of Russian interference in the 2016 presidential election. President Trump cannot abuse the powers of his office to obstruct a law enforcement investigation. Yet President Trump's use of the pardon power over the last 2 years raises concerns the president may have been willing to do just that to protect himself and his political allies. Since taking office, President Trump has issued pardons to former Maricopa County Sheriff Joe Arpaio, former Chief of Staff of Vice President Cheney, Mr. Scooter Libby, and conservative author Dinesh D'Souza, as well as Jack Johnson and some other celebrity? Somebody that knew a celebrity. She was from my district, in fact. President Trump's pardoning of these individuals, whose circumstances and convictions closely track with those of his former associates, including Michael Cohen, Paul Manafort, and Michael Flynn, raised the possibility the president was signaling his willingness to issue pardons to discourage cooperation with the Special Counsel investigation or the ongoing investigations in the Southern District of New York. In fact, this past Monday, a lawyer for former Trump campaign foreign policy advisor George Papadopoulos, who pled guilty to lying to the FBI about facts material of the Special Counsel's investigation, revealed that she had petitioned the White House for a pardon on behalf of her client before Special Counsel Mueller announced the end of his investigation. Pardoning Mr. Papadopoulos would not be an act of mercy, or the pardoning of Mr. Flynn necessarily, or Mr. Manafort, or Mr. Gates, or the rest. Instead, it would only send the message the President of the United States believes it is acceptable to lie to the federal law enforcement officials. While I have concerns about many of the ways President Trump has used the pardon power, his exercise of the power has been commendable in some instances. Yes, that goes back to the celebrity's friend and my constituent, Alice Marie Johnson. Decades of the failed war on drugs, and thousands of federal prisoners like her whose clemency petitions merit the president's attention as well. It's my hope that going forward, President Trump will use this power to grant more meritorious clemency petitions. The sad thing is he's really only issued 2 that were meritorious, except for Jack Johnson, which was deceased. So that was done not to relieve somebody of a sentence, but really for President Trump's sense of justice from 80 years ago or 70 years ago. It was done posthumously. But Miss Alice Marie Johnson and a gentleman from Nashville were given pardons, and they deserved them, I think. But there are thousands and thousands of other people who deserve them too. They haven't gotten them. And from what I understand, the president has asked for a list of celebrities who should be pardoned. Not a list of poor African Americans who've been the subject of an unfair and unduly oppressive on minorities drug war, like Ms. Johnson, who came to the attention of Miss Kardashian. Yes, a name I can't remember, Kardashian. But celebrity connections. Anyway, I thank the witnesses for agreeing to appear today, and I look forward to their testimony. And I now recognize the ranking member of the subcommittee, the gentleman from Shreveport, Louisiana, Mr. Johnson. For his opening statement.
Thank you, Mr. Chairman. Thank you to the witnesses for being here. A little historical context. Article 2, Section 2, Clause 1, as you all know, of the Constitution provides that the President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. There are claims of abuse of the pardon power by the current President, and I'm sure we'll hear that aired today. But regarding the claims of abuse of the pardon power generally, I'd like to just at the outset here discuss briefly how executive dispensation has been employed more recently and contrast it with how the framers understood its appropriate constitutional application should be. In 2014, President Obama used the pardon power to commute the sentences of more than 1,700 federal drug offenders, resulting in their release from prison without an assessment of the individual merits of each of those cases. In the short time since then, at least 4 of those individuals we know have been sent back to prison for resuming their criminal activities. Further, that same year, President Obama unilaterally created a program, which he simply announced on television, that suspended immigration laws for over 4 million people who are in this country illegally, something that's not allowed under the immigration laws that were passed by Congress. As the Washington Post's own fact checker wrote, President Obama was asked, quote, about specific actions that ended deportations of a subset of illegal immigrants. Previously, the president said that was not possible, using evocative language that he is not a king or the emperor. Apparently, he's changed his mind, unquote. And indeed, a week after he announced his immigration law suspension program, President Obama announced in his own words, quote, the fact that I just took an action to change the law, unquote. In this last example, President Obama didn't have to act in violation of the law or in an unconstitutional manner. He had a legal and constitutional tool that would have accomplished the same end, namely the pardon power. Indeed, President George Washington and his Treasury Secretary Alexander Hamilton are good examples of how the framers understood the pardon power could be used to grant reprieves from enforcement of the law. President Washington made clear that executive authority to refrain from enforcement of the law extended only to narrow case-by-case determinations. For example, under his presidency, there was widespread violation of the federal whiskey tax laws, as there's widespread violation of the immigration laws today. But President Washington insisted that he had a duty to enforce the laws to the extent practicable, issuing a proclamation in which he referred to, quote, the particular duty of the executive to take care that the laws be faithfully executed, unquote. A delegation President Washington sent to Pennsylvania to discuss noncompliance with the federal whiskey tax with representatives of that state even reported that, quote, one of the conferees then inquired whether the president could not suspend the execution of the excise acts until the meeting of Congress. But he was interrupted by others who objected. In the end, with the nation's ranks of whiskey tax avoiders growing larger and larger, President Washington's response was not to suspend the whiskey tax laws for them, but rather to selectively exercise his constitutional pardon power to grant amnesty for some past crimes, conditional on the agreement by the recipients of the pardon to obey the law in the future. Indeed, the person charged with enforcing the federal whiskey tax was Secretary of the Treasury Alexander Hamilton, who years earlier, during the ratification debates over the adoption of the U.S. Constitution, wrote Federalist Paper number 74 that, quote, in seasons of insurrection or rebellion, there are often critical moments when a well-timed offer of pardon to the insurgents or rebels may restore the tranquility of the Commonwealth, unquote. As at least one of the witnesses here today will testify, the power to pardon is one of the least limited powers granted to the president in the Constitution. The only limitations in the plain wording are that the pardons are limited to offenses against the United States. That is, they cannot include pardons of civil or state cases, and that they can't affect an impeachment process, which is always available if supported by the popular will. As one of our witnesses today has written, The pardon power has been and will remain a powerful constitutional tool of the president. Its use has the potential to achieve much good for the polity or to increase political conflict. Only the wisdom of the president can ensure its appropriate use. With that, I look forward to hearing from all our witnesses here today. I thank you again, and I yield back.
Thank you, Mr. Johnson. Before I recognize the chair for his statement, I do want to mention that President Obama, in my opinion, didn't give enough pardons or commutations to people with drug cases. He investigated all those people too thoroughly, and if 4 out of 1,700 went back to jail, that's 0.3% of those issued. That's a pretty good score. And that means 1,696 people got justice. Mr. Chairman, you're recognized.
I thank the gentleman, and I thank the chairman, and I thank him for that comment. Today's long overdue hearing examines the constitutional role and the limits of the presidential pardon power. Presidents are vested by the Constitution with the awesome power to absolve individuals of federal crimes. This power should be exercised carefully and responsibly. Unfortunately, President Trump has ignored the hard work of the career professionals in the Department of Justice's Office of the Pardon Attorney, who carefully scrutinize pardon applications and who make recommendations for clemency to the president. Instead, his exercise of the pardon power has created the perception that pardons are a political tool, a publicity stunt to curry favor with the public and a favor to bestow on the well-connected. Worse, there are some who believe that President Trump may be signaling the promise of a pardon to those with potentially damaging information about him, to encourage them not to cooperate with investigators. It is helpful to review this appalling record when it comes to issuing pardons. In August 2017, he pardoned former Maricopa County, Arizona Sheriff Joe Arpaio, who had been convicted of criminal contempt for defying a federal court order forbidding him and his law enforcement officers from racially profiling Latinos. Sheriff Arpaio was both a political supporter of the president and a hero to the president's base. But he was pardoned despite the fact that he systematically violated the constitutional rights of helpless people in defiance of a court order. The following April, President Trump pardoned Scooter Libby, former Vice President Dick Cheney's former chief of staff, who was convicted of perjury and obstruction of justice in relation to the FBI's probe into the leaking of covert CIA officer Valerie Plame's identity. And in June of last year, he pardoned noted conservative author and filmmaker Dinesh D'Souza, who pled guilty to a felony campaign finance violation in 2014. These pardons raise red flags for several reasons. First, none of the individuals I mentioned appear to have had their applications recommended or even reviewed by the Department of Justice's Office of the Pardon Attorney. Since the Civil War, the Justice Department has been responsible for administering petitions for executive clemency and preparing recommendations for the White House. While the President is not constitutionally bound to abide by this process, neither President Trump nor the Department has adequately explained why these individuals' applications had not undergone the usual review. President Trump appears to have cut the pardon attorney out of his decision-making regarding pardons entirely. As a result, not only has he made questionable decisions about who he has chosen to pardon, there may be many worthy candidates for clemency who have gone ignored. And where he has granted a pardon to a worthy candidate, it has generally only been when a celebrity friend such as Kim Kardashian West or Sylvester Stallone has lobbied on their behalf. There are also serious questions about whether President Trump has considered or attempted to use the powers of his office to shield himself or his political allies from legal jeopardy. Most troubling, there have been media reports that Michael Cohen, the president's former personal attorney, may have been offered the promise of a pardon by lawyers representing President Trump in hopes of convincing him not to reveal damaging information about the president. There is also a concern the president may have signaled the possibility of granting pardons to certain other individuals, including his former National Security Advisor Michael Flynn and his former campaign manager Paul Manafort, as a means of discouraging them from cooperating with investigators. Concerns have also been raised that by pardoning Mr. Libby for the same crimes several of President Trump's associates were accused of committing, he may have been signaling to those being targeted by investigators that a pardon may be in the offing if they refuse to cooperate with law enforcement. It is these concerns that prompted my request to several individuals, including former White House counsel Don McGahn, for any documents relating to possible pardons as part of this committee's investigations into potential obstruction of justice, public corruption, and abuses of power by President Trump. And this is one reason that we must see the entire report by Special Counsel Robert Mueller, and all of the underlying evidence so that this committee can make an independent judgment about whether the president has obstructed justice by abusing his pardon power to protect himself or his political allies. Contrary to what the president may believe, under any reasonable interpretation of the Constitution, the president does not have an absolute right to pardon himself or to use the pardon power in a corrupt manner. It is true that there are few textual restraints on the president's pardon authority, and there is little direct guidance from the Supreme Court on this issue, as well as on other issues that an exercise of the pardon power may raise. The president's pardon authority, however, cannot be read in isolation from the rest of the Constitution's text. For example, Article 2 of the Constitution also contains the Take Care Clause, which requires the president to, quote, take care that the laws be faithfully executed, unquote, and the mandatory presidential oath, which requires the president to swear to, quote, faithfully execute the office of president. I find persuasive the argument that the framers intended this language to impose upon the president a duty to abstain from self-interested conduct and abuses of power, or as one of our witnesses here today terms it, a duty of faithful execution. To interpret the Constitution otherwise would be to render any president into an elected tyrant who could wield the powers of the office to serve his or her personal needs at the expense of the needs of the nation. And let me say one other thing. There are those who argue that since the pardon power is granted to the president, he can use it completely as he sees fit, and that misuse could not be an obstruction of justice or an abuse of power. If you think a moment, this cannot be right. Let's assume that a president pardoned someone in return for a check, personal check of $50,000. I don't think anyone would think that because he had the unquestioned right to issue a pardon, that wouldn't be a crime, that wouldn't be an abuse of power, certainly, and probably an obstruction of justice. Given the framers' preoccupation with preventing arbitrary and abusive uses of government power, it is simply illogical to interpret the text of the Constitution to permit such an expansive view of the executive power. I thank Chairman Cohen for holding this very important hearing, and I look forward to hearing the testimony of our witnesses here today. I yield back the balance of my time.
Thank you, Mr. Chairman. Is Mr. Collins, does he have a statement he wants to enter? No? Okay. With that, we want to welcome our witnesses and thank you for participating in today's hearing. Your written statement will be entered into the record in its entirety. I ask you to summarize your testimony in 5 minutes, and you'll see the lights. Green is go, yellow is warning, and red is over. To help you stay within that limit, there are the lighting switches. Before proceeding, I remind each of you that your written and oral statements made to the committee within this hearing are subject to penalty of perjury pursuant to 18 U.S.C. 1001, which could result in the imposition of a fine or imprisonment for up to 5 years or both. Our first witness is Carolyn Fredersen. Ms. Fredersen is the president of the American Constitution Society for Law and Policy, a national nonprofit legal organization with increasing influence on legal and constitutional issues. Prior to working at ACS, she served as director of the Washington Legislative Office of the ACLU and as general counsel and legal director of NARAL Pro-Choice America. Extensive career serving in government as a special assistant to the president for legislative affairs during the Clinton administration, chief of staff to Senator Maria Cantwell, and as deputy chief of staff and counsel for Senator Daschle. Also has served as a law clerk for the Honorable James Oakes of the U.S. Court of Appeals for the Second Circuit. She received her J.D. from Columbia University, which I guess is in the chairman's district, maybe? Columbia in your district area? Absolutely. Yep. Where she has a Harlan Fiske Stone Scholar, it was, and served as editor of the Columbia Law Review.
And he lived in my district, too.
We have ended up getting a lot of people from Chairman Nadler's district, a lot of scholars. She received her BA in Russian and Eastern European Studies, summa cum laude, from a place that's an adjunct of Mr. Nadler's district, Yale University. Ms. Fredersen, you're recognized for 5 minutes.
Just one moment, point of parliamentary inquiry. Mr. Chairman, I noticed we're not going to administer the oral oath before their testimony. Is that right?
That's exactly right.
And the reason is because we don't want to include the phrase, so help me God, at the end?
No, it's because it's totally unnecessary. The statutes say that witnesses are subject to perjury and a penalty if they lie to the committee or tell a falsehood. So why have them stand up and swear to something that they're bound to? They're also not going to commit any other crimes they may commit here.
Mr. Chairman?
Subject to whether they swear to it or not.
Mr.
Yes,
Chairman,
sir, I yield.
I just thank you for yielding. I just want to comment here that swearing in witnesses may be relevant when you're talking about facts. Did this happen? Did that happen? Did you do this? Did you hear about that? When the witnesses are here to give their opinions, to have them swear that they are about to give their opinions as they in fact believe them, always seems a little strange to me.
Well, with due respect to Chairman Nadler, I do intend to ask the witnesses about facts, and I would like to know that they're going to assume that they will, but they'll offer truthful statements and understand that they are under the penalty of perjury if they don't. It's an important tradition that dates back to the founding of our country, and since we're talking about the history of the Constitution and our great traditions here, I don't think it's one we should abandon today.
Mr. Chairman?
Yes, Mr. Nadler.
I would point out that lying to Congress, whether under oath or not, is a crime.
And it's not a tradition. I was here in 2007 to 2010, and nobody was sworn in. That's something that started with the Republicans, and the votes have changed, and votes make a difference. You are recognized, Ms. Fredersen.
Thank you so much. To Mr. Cohen, Chairman Cohen, and Chairman Nadler, and the other members who are here, I'm very grateful to have the opportunity to speak before you in these hearings on the President's pardon power. I'm Carolyn Fredersen. I'm the President of the American Constitution Society. Despite Saturday's letter from Attorney General Barr interpreting the Mueller report, there are still many ongoing investigations of the President, his family, his businesses, his foundation, and there is still a broad concern that there could be a misuse of the presidential pardon. So it's helpful to review the history of the pardon power, its limitations, and how our founding fathers foresaw its possible misuse could threaten the country. The pardon power was intended to be a benevolent power. President George Washington himself issued the first pardon in what was decidedly an effort to use it in a benevolent manner. On November 2nd of 1795, he worked to end our nation's earliest uprising, the Whiskey Rebellion, using the power of the pardon to help heal the fabric of a young nation. Among the characteristics of the pardon power is that it is limited to federal crimes. State cases are beyond its reach, as are federal civil cases. And although there are important limits on an unfettered prosecution after a pardon, most notably the Fifth Amendment's double jeopardy clause, these limitations are not absolute. For instance, the Supreme Court has repeatedly confirmed that the dual sovereignty doctrine means that the Fifth Amendment's protection against double jeopardy permits prosecution of state offenses, even if the individual being prosecuted has already received a presidential pardon for a federal offense criminalizing the same conduct. Similarly, double jeopardy laws don't preclude federal civil lawsuits brought by private parties or the federal government. Third, it should be readily apparent to all, but the pardon power cannot be used to obstruct justice. The articles of impeachment drafted by the House Judiciary Committee against President Nixon provide precedent for finding the issuance of an obstructive pardon grounds for impeachment. Under those articles, it was stated that Nixon intended to, quote, interfere with the conduct of investigations and endeavored to, quote, cause prospective defendants to expect favored treatment through the use of the pardon power. An obstructive pardon can also expose the president to new criminal liability for obstruction of justice, witness tampering, and possibly even bribery, for which he could be indicted after he or she leaves office, and some, or many, believe even beforehand. Despite this history, now Attorney General Bill Barr theorized in his June 2018 memo that when the president exercises one of the, quote, discretionary powers, such as the power of appointment, removal, or pardon, that act cannot be the basis for a subsequent criminal prosecution, such as for obstruction. The Barr memo is puzzling for a number of reasons, but for present purposes, what is most striking is how utterly devoid of legal support Mr. Barr's conclusions are. Lastly, it is important to note that a self-pardon is also constitutionally suspect. Past presidents, most notably President Nixon, have asked if they could use the pardon power to save themselves, only to be told by counsel that no one may be a judge in his own case. And there is every reason to think that that opinion was and remains correct. The pardon power is an awesome power. When used as intended, it's a powerful tool for justice. However, it can also be a tool of greed, oppression, and perversion if used inappropriately. In fact, in 1788, at the Virginia Ratifying Convention, George Mason said that the president, quote, ought not to have the power of pardoning because he may frequently pardon crimes which were advised by himself. If he has the power of granting pardons before indictment or conviction, may he not stop inquiry and prevent detection? James Madison, immediately understanding Mason's concerns, replied that he too recognized that there was a danger to giving the president the pardon power. But if the pardon power were to be used improperly and to fall into unscrupulous hands, he said, the Constitution had a remedy: impeachment. Thank you.
Thank you, Ms. Fredersen. Our next witness is Mr. Justin Lorenz, and he is legal director of Protect Democracy and a lecturer at Harvard Law School. Previously served as special assistant and assistant counsel to the president during the Obama administration, senior counsel on the Senate Judiciary Committee to the Senator Sheldon Whitehouse, serves law clerk for the Honorable Diane Gribben-Motz of the U.S. Court of Appeals for the Fourth Circuit, J.D. from Yale. Y'all know each other? Bula Bula. Where he served as executive editor of the Yale Law Journal. He received an MA in history from Harvard and a BA in history from Yale. Mr. Florence, you're recognized for 5 minutes.
Mr. Chairman, members of the committee, thank you for calling this important hearing and for inviting me to testify. My organization, Protect Democracy, is a nonpartisan nonprofit organization with the mission of preventing the United States from declining into a more authoritarian form of government. I appreciate the opportunity to testify today on the role of the pardon power in our constitutional system and some limits that the Constitution places on that power. This committee's oversight can ensure that this power is used to provide mercy and justice as the framers intended and is not abused for corrupt or unlawful means. Limits on the pardon power begin with the clause's text, which excludes pardons in cases of impeachment and does not extend to pardons of state or civil offenses. In addition, the pardon power cannot be used in ways that violate other parts of the Constitution. As an example, it is well accepted that the pardon power does not extend to future crimes, for under our Constitution, a president can't license lawbreaking ahead of time. Or consider another scenario. It would violate the Equal Protection Clause and the First Amendment for a president to pardon all people of a certain religion of a particular offense, but nobody else. In my testimony today, I'll focus on 3 specific constraints on this power. First, because in our country nobody is above the law, both self-pardons and similar self-protective pardons are unconstitutional. Second, the president can't issue or dangle pardons in ways that violate generally applicable criminal laws, such as those prohibiting bribery and obstruction of justice. And third, the president may not issue a pardon that prevents courts from enforcing people's constitutional rights. Let me begin with the prohibition on self and self-protective pardons, which comes from the Constitution's requirement that the president faithfully execute the duties of his office and faithfully enforce the laws passed by Congress. The founders believed this constitutional command was so important that they included it in the Constitution twice, in the Take Care Clause and again in the Oath of Office. These faithful execution clauses bar the president from betraying the public good to serve his own interests. That means he can't pardon himself or pardon somebody else to protect himself rather than act to protect the American people's interest in the faithful execution of the laws. The Office of Legal Counsel in the Justice Department traditionally interprets executive powers quite broadly, but even OLC says that self-pardons go too far. In an opinion written days before President Nixon resigned, OLC opined that allowing the president to pardon himself would violate the fundamental rule that no one may be a judge in his own case. A self-pardon would reflect the sort of power wielded by a king, not an American president. And the same is true for a similarly functioning self-protective pardon. Turning to a second limit, the pardon power can't be used in a way that on its own violates our criminal laws. Consider a situation in which a Justice Department official takes a bribe in order to place a name on a list of proposed pardons. As then-Senator Sessions said in the context of President Clinton's pardon of Mark Rich, based on the law of bribery, if a person takes a thing of value for himself or for another person that influences their decision in a matter of their official capacity, that could be a criminal offense. And the same goes for obstruction of justice. If a federal official, including the president, issues or even offers a pardon to impede an investigation for a corrupt or wrongful purpose, that could run afoul of the law. Finally, I'd like to highlight a third limit on the pardon power. The president may not use a pardon to prevent federal courts from protecting people's constitutional rights. An essential component of the court's power to protect the Constitution is the contempt power, the ability to punish those who violate court orders. The Supreme Court has held that the court's role in our constitutional system hinges on their ability to prosecute contempt without relying on the executive branch. If the president could use the pardon power to block courts from protecting constitutional rights, we would no longer be a nation of laws, but instead subject to the whims of one man. Mr. Chairman, thank you again for holding this important hearing. The pardon power is a noble provision of the Constitution, but like any power, it can be abused. And so I would urge the committee to continue conducting oversight in this area. I look forward to the committee's questions.
Thank you, sir. Mr. James Fifner, University Professor at the Schar School of Policy and Government at George Mason University, previously named and mentioned in the testimony of Mr. Florence. His major areas of expertise are the U.S. President, Mr. George Mason. His major areas of expertise are the U.S. presidency, American national government, the national security policy-making process, and public management. He previously served as Special Assistant in the Director's Office, the Office of Personnel Management, and has taught at California State University Fullerton and University of California, Riverside. He has 3 degrees, a BA, an MA, and a PhD in political science from the University of Wisconsin in Madison. You're recognized for 5 minutes, sir. You turned on?
Chairman Cohen, Ranking Member Johnson, distinguished members of the committee, thank you very much for inviting me here to talk about the President's constitutional power to pardon. The text of the Constitution is pretty straightforward. Unlike most other powers of the President, it's unchecked. There's no check, virtually no check from the other branches of government. The original purposes of the pardon power were 2. First, to benefit an individual as an act of mercy. Maybe the justice erred, there was a problem. And also to temper justice by mercy. But the second and probably more important role is that of the public good, and James Wilson and Alexander Hamilton mentioned those things, for instance, to get the testimony of somebody who's committed a crime, to restore tranquility after unrest. But perhaps the broadest formulation of the pardon powers by President Ford, when he said he granted a full, free, and absolute pardon unto Richard Nixon for all offenses against the United States which he, Richard Nixon, has committed or may have committed or taken part in during the period when he was president. In terms of the limits of the present power, the pardon power, as has been mentioned, first, impeachment, of course, and second, that it must be a federal offense. Of course, the Supreme Court has heard arguments on Gamble versus the United States, where the dual sovereignty doctrine has been challenged. Can the pardon power be abused by the President? And my suggestion is yes, and it's derived from the English history, medieval kings, who arbitrarily often enrich themselves or promise pardons in favor for military service. Now, George Mason, the patron saint of my university, as been mentioned before, was against the pardon power. He was a Federalist. He thought that presidents would abuse it, and he said the presidents ought not to have the power of pardoning. If he has the power of granting pardons before indictment or conviction, may he not stop inquiry and prevent detection of his own crimes. But of course, Hamilton and Madison won that argument, and they said, if that's a problem, impeachment is the remedy for any abuse of the pardon power. Now, over U.S. history, over 30,000 pardons have been made by presidents, but most of them have gone through the Office of Pardon Attorney in the Department of Justice. The most contentious ones, colleague Jeffrey Crouch at American University has written a book and several articles arguing that President George H.W. Bush, who pardoned some of the Iran-Contra figures, President Clinton's pardons of Roger Clinton and fugitive Mark Rich, President George W. Bush's commutation of Scooter Libby's 30-month prison sentence for perjury and obstruction of justice were potentially abuses, but he also mentioned President Trump and argued that his use of the pardon power was potentially for political purposes. But whether any of these instances is an abuse of the pardon power, I think is a matter of political judgment and not of law or the Constitution. The only remedies for bad presidential judgments about pardons are political and not constitutional. On the other hand, a pardon might be legally questionable if there is, as been mentioned, an explicit quid pro quo for silence, exchange for silence or perjury. But of course, it would depend on the corrupt intent and the nexus, which is, of course, difficult to prove. That's why President Ford was so careful about insisting that there was no prior agreement with him and President Nixon before he pardoned him. Finally, just a few points about presidential self-pardons. The self-pardon was never mentioned in the Constitution, the Constitutional Convention, the Federalist Papers. No president has attempted it. No Supreme Court has opined on it. No president has publicly considered it, except, of course, President Trump has been quoted, "I have the absolute power to pardon myself." The arguments in favor of self-pardons are that they're not explicitly forbidden in the Constitution, but of course, the Constitution doesn't explicitly forbid a whole lot of other things. The arguments against, as has been mentioned in Federalist 10, James Madison said that no man should be allowed to be a judge in his own cause. And Chief Justice John Marshall in Marbury versus Madison said that one of the core principles of the U.S. justice system is that the government of the United States has been emphatically determined government of laws and not of men. A self-pardon would allow the president to put himself above the law. In writing the Constitution, the framers didn't mention a whole lot of other things, and it is arguable that they didn't even consider this as a possibility. And perhaps most importantly, a self-pardon would vitiate the Constitution, a provision of the Constitution that allows for prosecution after removal from office. If there were self-pardons, that part of the Constitution would be meaningless. Thank you.
Thank you, sir. And now for the testimony of Mr. Andrew Kent. Collegiate School students, listen well. Mr. Kent is a professor of law at Fordham Law School, also in the chairman's district, where he's taught since 2007. He teaches courses in con law, federal courts, foreign relations, professional responsibility, and national security law. He served as a visiting professor at Columbia University School of Law. He was a law clerk for the Honorable Robert A. Katzman of the U.S. Court of Appeals for the Second Circuit and for the Honorable Carol Amon of the U.S. District Court for the Eastern District of New York. He received his J.D. from Yale Law School and his A.B. in Social Studies, magna cum laude from Harvard College. Professor Kent is also the father of at least 2 up-and-coming young scholars. You're recognized for 5 minutes.
Chairman Cohen, Ranking Member Johnson, members of the committee, thank you very much for having me here today to talk about some difficult and somewhat novel constitutional questions about the use of the pardon power. My written testimony covers a number of topics, but I thought I would focus primarily on the question of whether a president could pardon him or herself. My conclusion is that, although this is a difficult question, I think the best answer is no. For some of the same reasons as my fellow panelists, but also for reasons of some recent scholarship that I've been working on with my 2 Fordham Law colleagues, Ethan Lieb and Jed Sugarman. We've we're in the process, I should say, of publishing a paper in the Harvard Law Review that for the first time really explores in detail where some extremely important language in Article 2 of the Constitution comes from. The so-called Take Care Clause, which binds the president to take care that the laws be faithfully executed, and the presidential oath, which must be taken before assuming the office, in which the president is required to swear or affirm that he or she will faithfully execute the office of the president. There have been a lot of claims by courts and commentators over the years about what these clauses mean, but really nobody has figured out where they came from. And we did, and found that the roots of these clauses go back at least 1,000 years in English law. Certainly by the time of Magna Carta, it was well established that many different kinds of executive officers had to take oaths and sometimes were also bound by commands as well to faithfully execute their offices. We found that these clauses over time developed 3 meanings, what we call kind of the 3 core principles of faithful execution for executive office holders. They are first, that the office holder must act diligently, honestly, carefully, in good faith, and impartially when they execute the law or their office. Second, the officer has a duty not to misuse an office's funds or take unauthorized profits from the office. And third, the command of faithful execution is a promise not to act ultra vires beyond the jurisdiction or scope of one's office. And one of our interesting findings was that it was not only in some very powerful offices in Anglo-American history where these commands were imposed, offices like colonial governors, governors of the American states post-independence, senior officials under the Articles of Confederation government, but also as many lowly offices that had these commands as well, offices like the vestryman of a church, a weigher of bricks, or an inspector of agricultural products. So it was both high and low that were commanded to faithfully execute their offices. And as we note, these commands of faithful execution and their meanings actually look quite a bit like what today we call fiduciary duties that a fiduciary has. And at the core here is the duty to act in good faith for the public interest, not for reasons of self-dealing, self-protection, corruption, bad faith, or other personal non-public reasons. So we think that it is most plausible to view the faithful execution commands and promises that bind the president as limits on the pardon power. And we note in the paper, and I wanted to stress today also, that it would not be strange or unusual to find that our Constitution was limiting or restraining potentially dangerous executive power in ways that try to shape it so that it acts in favor of the public interest rather than private interest. In fact, the framers, although they took some of the powers of the English monarch, very much did not want to reproduce the British monarchy because of so many ills and problems that monarchy had revealed. So in addition to a new requirement, the English monarch did not have to swear to faithfully execute the laws. In addition to that new requirement, the Constitution also does a number of other things to prevent corruption and self-dealing that were experienced with monarchs, but we very much did not want to have here. So, for example, the president is barred from having any titles of nobility, to stop foreign governments from being able to, dangle some kind of promise or title or lands that might influence the president. The president is barred from taking emoluments of office besides those that are allowed by law. The president is given a salary, in contrast to the English king, who tried to monetize the monarchy. Could go on, but the core idea is that the interpretation we give to these commands of faithful execution is very consistent with many provisions of Article 2 of the Constitution that seek to restrain the president not to be someone who abuses their office for personal ends. And for those reasons, we think that a self-pardon would be utterly inconsistent with the idea of faithfully executing the office.
Thank you, Mr. Kent. I appreciate your testimony, Professor Kent. We'll now proceed with 5-minute rule of questions, and I will begin by recognizing myself for 5 minutes. Firstly, I had introduced H Joint Res 8 on the first day of this Congress, January 3, 2019, with several co-sponsors, Mr. Raskin, Mr. Liu, Ms. Jayapal from this committee, to change the pardon power. And what we proposed was that the president shall not have the power, he shall not have the power to pardon himself or herself, president's brother, sister, brother-in-law, sister-in-law, spouse, parent, child, grandchild, or spouse of the president's grandchild, president's aunt, uncle, nephew, niece, or the spouse of the president's nephew or niece, or the president's first or second cousin, the spouse of the president's first or second cousin, the president's mother-in-law, father-in-law, son-in-law, daughter-in-law, or any current or former member of the administration, or anyone who worked on the president's presidential campaign as a paid employee. Ms. Fredersen, do you think the pardon power needs to be amended? Mr. Madison said yes, the remedy is impeachment, but most pardons have been issued on the last day. Impeachment's kind of not a very effective prohibition. Ms. Fredersen?
Well, thank you, Mr. Chairman, for your question. I have to say I haven't looked deeply into your legislation. I think, on balance, the pardon power has been exercised with restraint, perhaps too much restraint by presidents, as you mentioned about President Obama. And when it's done correctly and with mercy, with benevolence, as it was intended, it is an incredible tool for justice. So I think I'd have to spend some time thinking more deeply about whether or not it should be amended. I think there are already some very significant limitations on its use when it is, as I mentioned in my testimony, used inappropriately or with corrupt intent. So I think the strength of the Constitution is that that's already implicit. So I would just leave it there.
Well, we went to a pretty good length of family members, and you know, when you get to a family member, it's almost self-dealing, and it is putting. Mr. Florence, you mentioned self-protecting pardons. What exactly would a self-protecting pardon be?
So a self-protective pardon is a pardon that has the same purpose and effect as a self-pardon, in that what it's doing is allowing the president to place himself beyond the reach of the law. So for example, if a president says to a witness in an investigation, go ahead, change your story, don't answer the questions, don't cooperate because there's a pardon coming for you, in a way that leads the witness to do that terminates the investigation or interferes with the investigation, and that is an investigation that involves the president himself or the president's campaign or business organization or family members, that self-protective pardon that's dangled or issued, even though it's not to the president himself, it has the same purpose and the same effect of placing the president above the law. And as we've all testified, there is one kind of central tenet of our Constitution, which is the rule of law applies to everybody, that nobody is above the law, that nobody can be a judge in their own case. And so if the president can use that pardon power to make himself a judge in his own case, to place himself above the law, that violates a core principle of our Constitution.
And Ms. Fredersen said that our pardon powers work pretty well, and it has worked pretty well, I guess, but because it has doesn't mean that it will. And we never had a president who said, I can pardon myself. I mean, just nobody ever thought about it. I'm sure George Washington and Mr. Mason and Mr. Madison never thought what could happen in 2018. Now that we've seen that that's a possibility, that a president has such an expansive perspective of his own power and his potential own criminal liability, don't you think we ought to change the pardon power, Mr. Florence, in some ways?
You know, I think one option would be to amend the Constitution to make that crystal clear, but I think there are other ways to prevent abuse of the pardon power, including a self-pardon. And this committee has a really important role to play in that. It's doing that by holding this hearing and by conducting oversight into presidents who try and use the pardon power in that way. As we've all, I think, also said—
How would you go ahead enforcing it? Let's assume a president pardoned himself. You'd have to have an attorney general to bring the action, would you not? Who would have standing to go to court to question that pardon?
So, you know, courts are one actor in the system that can decide how to enforce things, but Congress can offer its own remedies through oversight, through political accountability, through other forms of accountability, and prosecutors within the executive branch can decide to take various law enforcement actions. And so you could ultimately have, you know, either through Congress or the executive branch, this question teed up for a court. I think what we have all said here is that you've got to read the pardon clause alongside the rest of Article 2, alongside the Constitution, and that there are provisions there now, the take care clause, the oath, that prevent this type of self-interested abusive pardon that places somebody above the law. And so we shouldn't lose sight of that, even if we look to be a little bit more clear going forward in how this works.
Professor Kent, do you have any thoughts on amending the Constitution to prevent abuses?
Well, you know, it's always difficult and, you know, given the 2/3 requirement, perhaps impossible in the present circumstances. I mean, I guess the one thing I would note is I do think Congress could have some legislative power. I think there's some possibility of doing things without amending the Constitution. And I think certainly, you know, one principle would be that Congress can legislate Congress could legislatively prohibit uses of the pardon power that are unconstitutional in themselves, right? So if those of us on the panel here today are correct that a presidential self-pardon is unconstitutional, then I don't think a constitutional amendment would be required for Congress to say so.
But don't you think, well, I agree with you, and I understand your legal logic. It's not in the law, it's not in the Constitution, and can we pass a statute that basically limits what is an unrestricted power to pardon based on a legal theory that three brilliant professors agree on.
Yeah, you could, and if the president tried to do so and he were later criminally charged, as Mr. Florence said, that would be, that would be a proper case that the judiciary could resolve. I mean, I do agree with some of the things that have been said, which, the president's pardon power is extraordinarily broad, and it is subject to very few limitations. I just think it is not subject to zero limitations. So, there would, I think, be some very hard constitutional questions about Congress doing anything beyond preventing or legislating against a self-pardon. Once you move out beyond the president himself, you do get into areas where, the executive branch would have some very strong constitutional arguments that that's improper. But again, also there's other forms of checking besides statutory prohibitions.
Thank you. And I know I'm over my time, but I am the chair. Mr. Fiffner, do you have any thoughts on this?
It seems to me that Congress, it's clear that Congress can't limit this straightforward power of the president. It might be reasonable to say that there's no self-pardons, and it might be reasonable to say the president shouldn't pardon his relatives and friends or so forth, but I don't think that that would be constitutionally enforceable. So I think the argument against it depends on the Constitution itself, not on what Congress may do. Nevertheless, it might be reasonable for Congress to pass a resolution saying that, but I don't think it would have constitutional effect.
Thank you, sir. And I now recognize the distinguished ranking member, Mr. Mike Johnson.
Thank you,
So help you God.
Thank you, Mr. Chairman. So help me God. Ms. Fredersen, 5 days ago, you authored a press release for your organization which stated, quote, "The question isn't whether members of the Trump campaign conspired with Russia to sway the 2016 elections. We already know they did," unquote. But just 2 days later, a summary of the report of the special counsel was released, which contains the following quote from the report itself. "The investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities," unquote. Since you previously wrote that we already know that members of the Trump campaign so conspired, what reasons do you have to doubt the validity of the opposite conclusion as reached by the special counsel with all his vast resources, time, and unlimited discretion?
Well, thank you for that question. I appreciate it. I would say, funny thing was that my piece came out 2 days before the report, but I'd also say, very importantly, or not the report, but the interpretation, that as you said, as you quoted from Mr. Barr's letter, he said that Mr. Mueller's investigation did not establish conspiracy. However, what we don't know is what the standard of proof was and what the evidence was, which was clearly, there was some evidence. And we know that the Trump, various members of his campaign manager, and many others had direct contacts with Russians. There were over 100 contacts between Russians and Trump associates. They changed the Republican platform on Ukraine. Paul Manafort was convicted of not disclosing his relationship with Russian-associated people in Ukraine to lobby on their behalf. And so, I think you can draw the conclusion pretty clearly that there were relationships between the Russians and the Trump campaign. And nothing that you've said makes that any less true.
But just to be clear for the record, you don't have any additional special insight into all these facts than Mr. Mueller does, the Attorney General Barr, Deputy Attorney General Rosenstein. Are they incompetent in their jobs? Do they not know how to interpret that evidence? Do you have some special information about that none of us, the rest of us, know?
I think there is a very large amount of information about contacts between the Russians and the Trump organization. And as I've said, I can read to you the number of people who've been indicted, who've pled guilty, who've been convicted because of relationships with the Russians.
We all know that, but we also know the outcome of the special counsel's report. Let me ask you, you also wrote an op-ed that appeared in the New York Times on March 22nd, and it was entitled, "We Don't Need to Read the Mueller Report." Can you please explain to us why you think we don't need to read the Mueller report?
Well, first I should say, unfortunately, I didn't get to choose the title. However, if you actually read what the piece said, you'll see it says clearly the report needs to be provided to the public and to Congress. However, even if this administration puts up a struggle over providing what Congress and the American public are entitled to. Nonetheless, because of the variety of information that has come forward, and even from looking at the indictments and the process of prosecution that has gone forward under the special counsel, but also in the Southern District of New York, in the Eastern District of New York. Now we have Cy Vance in New York, the Attorney General of New York, many other legal actors who are investigating this president. We have a lot of information that leads us, I think, to be very disappointed in how this president has behaved as president, the indications
I'll reclaim
of
my
corruption.
time. I'm running out of time. Look, you also, October 19th, 2017.
I'll give you some more time.
Yeah, he's the chairman. He can do whatever he wants. You signed a letter to members of Congress that was entitled, quote, "Benchmarks for Ongoing Congressional Investigations." Oh, for Ms. Florence. Mr. Florence, sorry. You did this one. All right. Let me grill you a little bit. Okay. You wrote this letter, Benchmarks for Ongoing Congressional Investigations into Russian Interference in U.S. Elections and Related Matters. Okay, and in the letter you recommended that each committee should issue a public interim investigation or report or public update that includes the following elements. How many full-time and part-time staff are currently assigned to the investigation, making up how many full-time employees slots, the training or experience of the assigned staff in conducting investigations, how much money was spent on the investigation in total and since the last report, how many hearings have been held, et cetera, et cetera. My question is, do you think that same report entailing that same kind of information should be made by the special counsel's office?
So I think it's important for the special counsel's office to provide this committee with all kinds of information, including how it went about conducting its investigation, what it learned from that investigation, what evidence it uncovered, what conclusions it drew from that. And so I think as much information as this committee wants to request and the special counsel can provide would be useful to this committee's oversight.
But just for the record, of course, the Attorney General's summary of the special counsel report included that in the investigation, they spent $25 million, by the way, but they also employed 19 lawyers, 40 FBI agents, 2,800 subpoenas, executed 500 search warrants, 230 orders of communication records, 50 orders authorizing the use of PIN registers, 13 requests to foreign governments for evidence, and interviewed approximately 500 witnesses. In your professional opinion, would you say that's thorough? That's a thorough investigation?
From everything I know, the special counsel's investigation was thorough, and I think what's so important is for both this committee, for Congress as a whole, and for the public to learn what the special counsel found. A 4-page summary letter can't do justice to all of that work, and so I appreciate that this committee has asked for those materials, and I think once the American public can see them, they can see how much work the special counsel did and what he truly found from doing that.
Appreciate it. I'm out of time, and I'm not the chairman, so I can't elaborate further.
You did go 1 minute and 12 seconds over. I don't want you to get used to that because we don't want you to have that prerogative. Mr. Raskin, you're recognized.
Thank you. Just want to tell my distinguished friend from Louisiana, if the Mueller investigation cost $25 million, I'm looking at a headline here saying that Trump's travel to Mar-a-Lago cost taxpayers more than $64 million. So that's just flying in the Secret Service and so on. You know, in that interesting numerical recitation of the number of lawyers in the Mueller investigation, which was, of course, appointed by a Republican Attorney General, and Mueller's a Republican, and so on, the lawyers and the depositions and so on. One thing we didn't get was the number of pages in the Mueller report. And I wonder how many pages are in that? Is it like 800 pages or 200 pages? Because we've got the right to read that. But let me get back over to our distinguished witnesses today. You guys make me miss academia. And thank you very much for your thoughtful testimony, all four of you. First of all, just to be straight, does everybody on the panel agree that the president cannot sell a pardon and put it up on eBay and take the highest bidder? Just, does everybody agree the president cannot sell a pardon? Ms. Fredersen?
Yes.
Mr. Florence?
Yes.
Not on eBay.
I take that to be a yes. And Mr. Kent?
Yes.
Okay, and let's go back the other way. Does everybody agree the president cannot pardon himself because of the Madisonian principle that no man may be a judge in his own cause because it will impair his integrity and corrupt his judgment? Yeah.
And for other reasons, yes.
And for other reasons, yes. Mr. Fiffner?
That's a compelling argument.
Yes. Mr. Florence?
Yes, I agree.
Okay.
Yes.
Ms. Fredersen, okay, so everything's very clean. This is what I don't miss about academia. What do you do if the president does pardon himself? You all say it's unconstitutional and think that's the end of the matter, but let's say the president issues a pardon to himself. Now, are you just asserting at that point it's legally null and void, that if the president is later prosecuted, that a court should disregard it? Or are you just saying the president can still be impeached and convicted for it? Well, what does it mean if a president does try to pardon himself? And perhaps, Ms. Fredersen, let me start with you.
Well, I think both of those things could be possible, that it's null and void, and that he's also can be prosecuted, certainly can be impeached.
Okay. Did anybody else want to weigh in on this?
I think John Marshall said that the Supreme Court can say what the law is, so it seems to me that constitutional decision could be decided by the Supreme Court.
Gotcha. Mr. Kent, let me ask you a question. I'm fascinated by your research on the history of the Take Care Clause. And I know you're here to talk about the pardon power, but it may be illuminating as to Attorney General Barr's 19-page single-spaced memorandum making the argument that the president cannot, as a matter of law, ever be subject to an obstruction of justice prosecution because he controls the law enforcement machinery. This is the insurgent, now unitary executive theory of presidential power, essentially that the president has complete control over the executive branch. So even if he were to interfere, say, corruptly or in a self-interested way to try to squelch an investigation or kill an investigation of a friend like Michael Flynn, that could not be obstruction of justice. How does that relate to your historical investigation about the meaning of the Take Care Clause?
Well, certainly it would not be a good faith, public-spirited execution of the office to have engaged in any of the acts that you describe. And so I think there's a strong argument that they're unconstitutional and void. But certainly—
So you would say not only could it be prosecuted, but you're saying it itself could be interpreted as unconstitutional, totally outside of the Constitution.
I do, and I also agree with the many critics of Attorney General Barr's fairly aggressive theory of presidential non-accountability. I think certainly presidential acts can, even though they're within the scope of Article 2 powers to make, can be treated as bribery by a prosecutor, can be treated as obstruction of justice by a prosecutor. There's not something magic about doing something pursuant to an Article 2 power that means you're entirely immunized from criminal liability.
Okay. Ms. Fredersen, let me come back to you since the door was open to getting your thoughts on the current crisis this week. Let me ask you, by what right did Attorney General Barr decide to, or by what right did he take to himself to decide the question of whether or not the president had obstructed justice? Did he have the right to do that?
Well, I think that's the big question and the big concern. It seems inappropriate that he placed himself in the role of deciding something that Mr. Mueller left undecided and more appropriately left to this committee, to the subcommittee.
Did he decide it on the basis that he'd spelled out in that 19-page memorandum, which is the president can never be guilty of obstructing justice in the executive branch of government because he controls the executive branch of government?
Well, it's certainly possible. It's very little is spelled out. I think it's an important reason for Congress to hear from Mr. Barr directly, as well as from Mr. Mueller, who apparently was not consulted in the drafting of this interpretation of his report. So, I think those are very important questions because it's incumbent on Congress to have an answer to whether to what Mr. Mueller actually found.
Let me ask one final question, and perhaps Mr. Florence, you could answer this. For many decades now, I think the president has followed the formal pardon process. There's a pardon attorney in the Department of Justice. There's a formal process for petitioning, goes through, there's a recommendation and so on. This president, of course, with the Sylvester Stallone and, so on, has gone completely outside of that and has just written letters. Are there any formal requirements for a pardon, or really could the president pardon somebody by a tweet? And watch something on TV, get upset about it, and say, I'm going to pardon this person?
So I think as a formal matter, a warrant has to issue from the White House. As to the process, I think that process is helpful in protecting against some of the violations we've talked about and maintaining safeguards. I don't think that process is constitutionally required, and so If the president wants to sit down and write on his pad, I grant a pardon, he's constitutionally permitted to follow
Well,
that
don't fight the
process, but
hypothetical. I'm talking about a tweet here. I'm not talking about a legal path.
I think a tweet would not have legal effect in executing a pardon.
You mean a tweet is not anticipated by the Constitution?
Thank you, Mr. Raskin.
I yield back. Thank you, Mr. Chairman, for your indulgence.
I now recognize the gentleman from Virginia who made a marvelous maiden speech in this committee, and now he's got high hopes for a second one.
Thank you, Mr. Chairman. I want to follow up a little bit on the previous questioners now that the door's been opened, so to speak. Ms. Fredersen, you stated that there is a lot of information out there about the relationships, as you put it, between the Trump administration and Russia. Are you aware of any actual evidence to support an allegation of collusion between the Trump administration and the Trump campaign and Russia?
As I mentioned, it's been well documented that there were over 100 contacts between Russians and various members of the Trump campaign, the Trump family, and up to the Trump administration.
Where has it been documented?
If you've been reading the newspaper or watching television, it's been all over the place.
Publicly available?
Publicly available.
Okay. So given that the special counsel issued more than 2,800 subpoenas, executed nearly 500 search warrants, interviewed approximately 500 witnesses, issued approximately 50 orders authorizing use of pen registers, do you believe that he was, that he had this information as well?
I think it's really important to read how it was phrased by the Attorney General, which is that it was not established. He didn't say there was no evidence. There's clearly some evidence, and I think it's important that Congress examine it, because even if, and one has to actually see the full Mueller report to understand how he evaluated the evidence, but even if there wasn't enough to show beyond a reasonable doubt, and one assumes that's the standard that he was using, although perhaps not the appropriate standard for an indictment, one has to ask, was there enough for Congress to find highly problematic relationships between the variety of players representing either officially or in some private capacity the Russian government with the Trump campaign, with the Trump administration? I think those are all very important questions for Congress to examine.
So with regard to conspiracy, the issue of whether or not there was obstruction of justice, the question is, does the department have the authority to determine whether the evidence rises to the level of a chargeable offense?
Well, it's very interesting because I think, as Attorney General Holder has stated, in his 6 years in running the Justice Department, he never had one of his prosecutors present him with a case and not come to a conclusion. I think one has to look historically at the other times when there has been an obstruction of justice inquiry into presidential behavior, and in those particular circumstances, that has been presented to Congress to resolve, and I think one can intuit that that's perhaps what Mr. Mueller was thinking, and that nonetheless the Attorney General put himself in the place of Congress and made that decision.
So it does not, that power does not reside with the Department of Justice to determine whether an offense?
I didn't say that, but traditionally it's been with the prosecutor who's been leading the investigation to recommend a decision, and in this case, Mr. Mueller didn't. Again, consistent with past obstruction of justice inquiries into presidential behavior, and certainly quite unprecedented for the Attorney General to substitute himself in this way.
Unprecedented for the Attorney General to determine that there's not enough evidence to proceed with the charging of an obstruction of justice charge.
As the Attorney General Holder said, he'd never experienced such a situation in his 6 years running the Justice Department when there was no recommendation from a prosecutor to conclude an investigation. And Mr. Mueller said very directly, and that was actually quoted by the Attorney General, that the president was not exonerated.
Thank you.
Thank you, Mr. Klein. I now recognize Ms. Garcia from Texas.
Thank you, Mr. Chairman, and I wanted to start with you, Ms. Fredersen, just to clear something. I know that the statement was made earlier about, in discussion of a pardon, and a reference was made to President Obama's orders on DACA, which was a deferred action. Would you find any way that any deferred action of deportation would be the same as a pardon? Yes, ma'am.
You know, it's a very novel theory, so I haven't really engaged with it. So I
Does anybody else agreed with that characterization?
It seemed that President Obama used presidential prosecutorial discretion as a directive to DHS to do that, so it doesn't sound like a pardon to me.
Well, thank you. I think I agree with you on that, and I was sort of taken aback when that comment was made. I just wanted to clear it up. But Ms. Fredersen, I want to go back to you. You mentioned earlier that the word "did not establish" was very, very critical in the discussion of the conspiracy and coordination. Is it also interesting that the word collusion was not used? It was just conspiracy and coordination?
Well, I think it's just a reflection of the fact that collusion's not technically a legal term. And so Mr. Muller was referring to the actual legal terms, and collusion is one that sort of encompasses the variety of ways that coordination or conspiracy can happen, but it's not technically a legal term. So I think I wouldn't find more to it than that.
Okay. Well, thank you for that. Then I wanted to ask you, do you agree that the Constitution bars an obstruction of justice inquiry that might examine the president's subjective motive behind a facially legal exercise of a discretionary power because the burden would be too great on the executive branch?
No, certainly not. I think it's one of the elements of obstruction of justice, and if that were not, if that could not be investigated, then the president could never be investigated for obstruction of justice.
Right.
That can't be right.
So could you just kind of tell me just a little bit more so that the average viewer who's listening to us that's sort of kind of lost of how this really works, what does that really mean?
Well, what's the intent behind the action? So
Yes,
maybe
ma'am.
technically legal, but if it's done for an illegal purpose, it could still be illegal. So I think that's the essence of the way that inquiry works.
Right, because I find it interesting that when I go back home, people just don't understand what we're really doing, that frankly they think that the president could just tweet Sylvia Garcia's pardon and that it's done. So would one of you, maybe you, sir, could take I can't see your name, is it Justin?
Justin Florence.
I can't read Florence, but I can read Justin, so forgive me for using your first name, but can you just kind of pretend that you're talking to, I don't know, a middle school in my district, and you want to explain to them how pardon really works? When does it start? Can you do it? Because you've clearly said you can't do it for future crimes. We already heard reports this morning that at least one campaign aide, Papadopoulos, who had pled guilty on one of the things arising from this whole episode, his lawyer has asked for a pardon for him. So is this something a lawyer has to do? Who does it? When? And again, just, you now have less than a minute to explain to a middle school class in my district, what the heck is this all really about?
Sure, I'll give it a stab, and I think these concepts are ones that everybody can understand, and so we shouldn't obfuscate.
Well, obviously they've been litigated.
So our criminal justice system can be harsh at times, and as a safety valve for that, the Constitution includes the pardon power that allows the president to decide in some cases that an injustice occurred or that somebody is entitled to mercy and a second chance and redemption, and the president can shorten their sentence or can say, I'm going to take this crime away and take it off your record because you've served your time, you're entitled to a second chance. The president has broad authority to decide when to do that and when he thinks it's the right thing to do. And there's not a lot of procedural rules about how that happens. Different presidents follow some different processes. This president talks to Kim Kardashian. Other presidents require sort of formal petitions and explanations for why this should happen and consult with a lot of people. The problem is, and what I think we're talking about today, is that that power can be abused in some cases. And when the president uses that power to undermine our system of checks and balances, or to undermine the principle that nobody in our country is above the law, then that power can take our constitutional system and throw it out of whack. And so it's really important for this committee, for the Congress.
But again, do you do it at the beginning of somebody's trial? I mean, like Papadopoulos, he didn't do it at the time he pled guilty. You know, the lawyers are now exerting that request. I mean, when can it happen?
As a legal matter, the president can pardon any crime that has been committed, including before the person has been charged, before they've been prosecuted, before they've been convicted. What they can't do, although this isn't in the text of that one clause, but it is in the Constitution, they can't pardon future crimes that have not yet been committed. But in principle, it's okay for a president to say, you know, I know you haven't yet been charged, but I think mercy and justice entitle you to a pardon here. Now, what can't happen is to do that for purposes of getting the president himself out of trouble and of allowing the president to shut down an investigation. That's something that I don't think can happen.
Right, and I think all of you seem to be in agreement that he can't pardon himself, but I know one question I get again in the district from many of my constituents is, can he pardon his children that all, especially the two that work at the White House, or his wife?
Yes. Excuse me. The president can pardon anybody except, I would argue, himself. And asking for a pardon is okay, but if you're talking to your middle school students, I say, but pardoning somebody in exchange for lying, say, to a jury, that would be a bribery or obstruction.
Or for money.
Pardon?
Right. It would be illegal to do it for money.
No, it would not be legal to do it for money.
Well, correct. I said it would be illegal. We're saying the same thing.
Illegal, okay.
But we don't want to confuse the students. We're trying to make sure they understood. But yes to the children, and yes, he can even pardon his wife.
Yes.
Okay.
Constitutionally, it may not be right, it may not look good, but constitutionally, I think it would be hard to overcome that.
All right. Well, thank you, and I yield back my time, Mr. Chairman. Thank you.
Thank you, Mr. Jacobs. I now recognize gentleman who will wrestle with you, Mr. Jordan.
Thank you, Mr. Chairman. Mr. Pfiffner, assuming no quid pro quo, no payment or anything like that, and assuming they're not talking about themselves, just to be clear, does the Constitution give the President of the United States broad and almost absolute authority to pardon others for federal crime?
Correct.
Correct. He gets broad, almost kind of blanket authority that the President has, assuming he's not trying to pardon himself or anything that was just discussed with the previous member of Congress. Okay, so the ones that he's done this year, so let's talk about the current president, President Trump, the pardons he's given. Has he done anything wrong with those particular pardons?
You or I or many people might think that it's an abuse of power, but he has the constitutional authority to be able to do that legally, yes.
Joe Arpaio was fine.
Pardon?
Mr. Arpaio was fine. One of the pardons, Mr. Arpaio.
Constitutionally and legally, yes.
Scooter Libby was fine.
Legally, yes.
Okay. Jack Johnson.
Well, that is posthumous and maybe not necessary, but sure.
No one got paid there, right? Right? Mr. Johnson, he's passed away, right? So that was fine, right?
Yes.
How about Dinesh D'Souza? Is that okay?
Yes.
And I think the other one was Mr. Saucier, is that right? I think there's been 5, is that correct?
Whoever, yes.
Whoever, yes, so that hasn't been a problem. And how about any sentences that were commuted? Miss Johnson, Alice Johnson, I think.
Sure, commuting sentences is part of the pardon power.
Same thing. So we got this hearing and all, we're all this concerned, but there has been no problem whatsoever thus far with this power as is currently under the Constitution. We have a bill that wants to change it, but it's worked out all right, hasn't it?
There could be problems with it, but there's not a constitutional or legal prohibition on it.
Fine, thank you. Ms. Fredersen, let me go back to where the ranking member was. I want to look at what you said 5 days ago. You wrote for a piece, where'd you write the piece? Was this in the newspaper, or was this a statement, or press release? Excuse me, press release. The question isn't whether members of the Trump campaign conspired with Russia to sway the 2016 elections. We already know they did. You stand by that statement?
We have much evidence, as I've answered several times already.
Let me read from the special counsel's, well, the letter by the Attorney General referencing the special counsel's report. It says this: the special counsel did not find that the Trump campaign or anyone associated with it conspired or coordinated with the Russian government in these efforts.
The Attorney General's letter said that that conspiracy was not established. They examined evidence. There's evidence. Does not necessarily mean that the special counsel decided to move forward.
So I guess the question is
Bob
Mueller wrong?
We need to see what he found.
That wasn't my question. My question is Bob Mueller wrong?
I'd have to look at the evidence, as I think Congress needs to.
The special counsel did not find that any U.S. person or Trump campaign official or associate conspired or knowingly coordinated with Russia. The special counsel did not find that the Trump campaign or anyone associated with it conspired or coordinated with the Russian government in these efforts. Despite the interesting clause that follows next, despite multiple offers from Russian-affiliated individuals to assist the Trump campaign. So multiple times they dangled the fruit in front of them, and they chose not to take it. And yet you said, we already know they did. I'm trying to figure out who's right, you or Bob Mueller.
I think we need to see what Bob Mueller was examining. It looks from the Attorney General's letter that it was limited to only the hacking and leaking and the Russian troll effort, as opposed to some of the other evidence that we've seen in the public
But you were dogmatic. You were emphatic. You said, we already know they did. And 2 days later, the special counsel, via the letter from the Attorney General of the United States, says, no, they didn't. So someone's right and someone's wrong, and I'm just trying to figure out who it is.
I have to refer back to what I said earlier. There are over 100 contacts between various Russians and Russian-affiliated people with the Trump campaign, the Trump administration, the Trump family, and that's certainly evidence. If Mr. Mueller didn't find it conclusive, then I think it's up to Congress to examine.
That is not evidence of conspiring, collusion, or coordination. That is not. Because he said this, based on these activities, the special counsel brought criminal charges against a number of Russian military officers for conspiring to hack into computers in the United States for purpose of influencing the election. But the special counsel did not find that the Trump campaign or anyone associated conspired with Russians, even though they were given multiple chances to do so. They chose not to do so. But yet you pronounced to the whole world 2 days before this letter, we know they did.
Will the gentleman yield?
No, I got 8 seconds. All I'm asking is Bob Mueller wrong? And you're the head of the Constitutional Society, so I want to know what your thoughts are.
Much public evidence that there were contacts between many Russians, and not just the Russian government, but private people who were very close to the Russian government,
Ms.
with the Trump administration, the Trump campaign.
But that's not what you said. You said the question isn't whether members of the Trump campaign conspired with Russia. We know they did. So you're not talking about contacts. People can contact folks all the time. I bet Mr. Klein's a freshman member of Congress. I bet he's contacted foreigners because they come to see him, because it's important that they talk people from different embassies. That happens all the time. So contacts is a lot different than conspiring. You said 2 days before this letter from the Attorney General, we know they conspired. And Bob Mueller said, no, they didn't. Very clearly, very often, and he even emphatically said they were given multiple chances to conspire and they didn't go for it. That is completely opposite of what you said 2 days before. And all I'm asking is, are you calling Bob Mueller a liar?
No, I'm not. But I do think that this Congress needs to look and see what that evidence was.
That raises one last question, if I could, Mr. Chairman. Are you going to take back your statement?
Once the Mueller report comes out and the Congress has had a chance to examine it, I'd welcome an invitation to come back to discuss it.
Mr. Chairman, I look forward to having Ms. Fredersen back in front of this committee.
Thank you, Mr. Jordan. Thank you, Mr. Jordan. The bar is recognized.
Thank you, Mr. Cohen. Thank you, Chairman. Thanks to everyone on the panel. Really appreciate your being here. Ms. Fredersen, I want to allow you the opportunity to finish This has been a very interesting debate so far, but and just want you to answer one question. I think this is important for the public, and I think clearly it's important for this committee and subcommittee. Why should members of Congress want to see the Mueller report?
Well, thank you for that question. As was elaborated earlier, this was quite a lengthy and thorough investigation and accumulated quite a lot of evidence. Certainly a fair amount of evidence on obstruction of justice to the extent that Mr. Mueller himself said that the president was not exonerated. I think that it requires Congress to examine what were the questions that Mr. Mueller was answering. What was the standard he was applying legally? Was it the standard to issue an indictment? Or was it the standard to actually convict, which I think is quite important and a difference that should be examined by Congress. And then how many different issues did he actually look into in terms of relationships with Russians?
And excuse me, I wanted to get to the different standards, because I think this is important for the American public as well to understand. What are the thresholds? What are the standards? We've not had the privilege yet, obviously, of seeing the report, and I appreciate the ranking member pointing out how many millions of dollars, how many attorneys have actually been utilized, the public resources put into this that require us, that give us an obligation to see the report. But what are the different standards that the American public should be aware of? Because and I'll actually let you answer the question.
Right, well, thank you. And I'd first just say that I have not been a prosecutor, so I don't speak from that experience. But generally, to issue an indictment is a lower standard. The grand jury determines whether or not there's probable cause. Whereas if a prosecutor bringing forth a case, putting a case in front of a jury has to prove beyond a reasonable doubt. And so, it's a question about whether and which standard was applied here. Which might have meant an indictment would issue if it were probable cause, but not under the higher standard. We just don't know. And I defer to my colleagues up here in case, we may have more experience in criminal procedure than I do. However, I'd say there's also a different standard in terms of Congress. And that's, your constitutional role of oversight to examine whether or not, even if behavior which didn't reach a threshold of beyond a reasonable doubt is nonetheless something that Congress needs to take action to correct. And that could be through many mechanisms, through certainly impeachment is always available to Congress under the Constitution, but you have the appropriations power, you have the power to make law, and so forth. So, I think that's another standard that, in this case is the most important standard for you to take to heart.
Thank you so much. And actually, Mr. Florence, I want to ask you about that behavior, because in your written testimony, you wrote, the president can run afoul of obstruction laws by dangling or promising pardons to influence a witness. And then you later write, the factual determinations necessary to determine whether dangled pardons violate the criminal laws can and should be determined through law enforcement investigations or through congressional oversight hearings. I'm curious as to your thoughts and opinions. We've seen the messaging that President Trump has put out through Twitter and through interviews in the media. What are your thoughts on whether the president has actually dangled pardons?
So I want to begin by pointing out why it's so important for Congress to look at this. The Mueller investigation was into whether a foreign government interfered in our election, and the special counsel did not exonerate the president from interfering in that investigation, from obstructing that investigation. So we have a foreign government that's attacked our democracy. I would hope that our executive branch is fully united behind investigating what happened there, who was involved in it, and what we can do to make sure it never happens again. And yet, we have a special counsel who, while being very measured, very cautious, is not able to exonerate the president from interfering in that investigation. That's scary. And so this Congress, this committee, needs to know, was the president trying to block an investigation into a foreign power altering or interfering in our elections. This committee can do that in a lot of ways. It can take testimony. It can start by getting the full Mueller report, all of the underlying evidence that it found, both into what happened in our election, what the Russians did, and into whether, how, and why the special counsel had some concerns that the president may have been trying to block that investigation. And that's something that I don't think is a partisan issue. We should all agree that our elections should be decided by American voters and by our country, and that we should all want to make sure that no foreign power interferes, and that when it does, we're all united to make sure that it doesn't happen again.
I agree. We should all be united, and some of us are trying to get to that. One last quick question. We've learned about the way, or we've discussed today about how the president actually circumvented what many people would consider a normal process for determining a pardon by at least getting some consultation. His consultation instead has been Kim Kardashian. Is there a way for Congress, without infringing on the broad constitutional power that the president has, is there a way for us to legislate that somehow, to put some transparency in a process?
I think transparency is the key word there, and that there are things that Congress can do with its legislative authority to ensure that if the president abuses this power, or if there's some suggestion he may be abusing this power, that Congress can make sure that doesn't go unpunished and unnoticed. And so a bill is offered by Mr. Schiff, the Pardon Abuse Prevention Act, that I think this committee may wish to look at, that makes sure when there is a pardon that may look to put the president above the law, that the underlying investigative materials can make their way to Congress, so that there's transparency and that nobody can use this one power to put themselves above the law and prevent the equal application of the law.
Thank you.
Thank you. And Ms. Sheila Jackson Lee, the successor to a great former impeachment member of this committee.
Thank you very much, Mr. Chairman. Yes, I had the experience of being a member of this committee in the impeachment proceeding that occurred in the 1990s. Let me thank the chairman and the ranking member. This is an extremely important hearing, and I thank the witnesses very much for their presence being here. I want to ask a question that would warrant just a yes or no. I'm going to take you down memory lane, and that is to recall in the fall of 2016, 17 intelligence agencies determined that Russia was attempting to interfere with the 2016 election. It fell around the fall time. I know that then Secretary of Homeland Security was extremely engaged in the process of working with other intelligence agencies to make sure that it was as broad a review as possible. Ms. Fredersen, do you remember that determination?
Yes, I do.
Mr. Florence, do you remember that determination?
Yes.
And Mr. Pfeiffer, do you remember that determination?
Yes, ma'am.
And Mr. Kent, do you remember that determination?
I do.
With that as a backdrop, I'm going to proceed with questions. That establishes that any thought, any facts, any presentations about Russia's involvement is predicated on the fact that in 2016, our intelligence agencies, 17, confirmed that they were attempting to do so. And that was in the midst of the 2016 presidential election. In the summer of 2017, I introduced HRES 474, and I asked the chairman unanimous consent to introduce this into the record.
Without objection.
This was a resolution in the midst of the ongoing hysteria and castigating of Director Muller, accusing the special counsel's work as a witch hunt, and frankly, members of Congress were frightened. So the resolution expresses the disapproval of any action by the president to remove the special counsel investigating the Russian interference in the 2016 presidential election, in opposition to the granting of pardons to any person for offenses against the United States arising out of Russia's activities to bring about the election of President Donald J. Trump as President of the United States. A number of members joined. This was a vigorous discussion, and I might say, Ms. Fredersen, it was evidence of the Article I body attempting to give oversight to what was seemingly threatening a rule of law, process of the rule of law. I'll read into the record the language, the opening language. The strength of the American constitutional system, designed in 1787 in Philadelphia, is the national government's separated powers in which the legislative, executive, and judicial branches serve as checks and counterbalances on each other, and fidelity to the rule of law is the highest value and responsibility. Very glad to say Mr. Cohen was a co-sponsor of this legislation, but Ms. Fredersen, would you then, may I give you an opportunity to, as you were making your comments, that was it in your mind that the Article I body, the Congress, had not been heard on the Mueller report?
Absolutely. That's an essential piece.
And offer to me what you thought we might do as a constitutional body, even in receiving the Mueller report. By the way, do you believe that we should immediately receive the Mueller report and its supporting documents?
Well, I believe that you should receive it as soon as whatever redactions that need to be made, consistent with the law, not overly expansive, are made. But that should be very prompt, and Congress is certainly entitled to. The Article I powers are clear. Congress has a role in oversight. Congress has to ensure that rule of law is upheld. And it is entrusted to you in the Constitution to make sure that the president himself is not above the law. So because of the breadth of this investigation, because of the dangers that you have enumerated, that it was meant to address, and that, according to our intelligence agencies, are still ongoing threats, it's imperative that this body take up the report and examine it. I think we still have a lot of questions about what might happen in the next election, and there may be lessons to be learned for that purpose as well.
Some will offer the fact that they believe the pardon power is unconditional. This committee has made a commitment to the American people to abide by the rule of law, and we will be looking at issues involving corruption, obstruction of justice, and the abuse of power. Mr. Florence, can there be, and what parameters would you suggest should be considered if the pardon power was abused?
I think this committee has a lot of tools at its disposal. The first thing that should happen is real oversight and investigation to find out what abuse has happened, to assess that, and to provide a report to the public so that the people can know what's been going on and make their own judgments. But the Congress has additional tools at its disposal that it can use in cases of abuse of power, up to including censure, impeachment, and other authorities, and it's ultimately for the Congress to make those judgments. What I would offer...
But let me just, you can abuse power with the use of the pardon power. That's what
It is a serious concern that the pardon power can be abused, and it is incumbent on Congress to prevent that abuse. One of the things that we've seen is that it is fairly rare, although not unprecedented, for pardon questions to get in front of the courts. There are various reasons for that, and one consequence of that is that it is so important for this body as a co-equal branch of government to make sure that abuse doesn't happen.
Well, would you be kind enough to offer just an example, we won't hold it to it, that might be an abuse of the pardon power?
So I will take your invitation and offer two. One is the president's pardon of Sheriff Arpaio. So Sheriff Arpaio was sued by private people for violating their constitutional rights. The court said he violated their rights. You got to stop doing that. It entered an injunction to tell him to stop doing that. He violated that court order again and again, and the court used its contempt authority to say, you've got to follow my order, you've got to stop violating constitutional rights. President Trump then issued a pardon to pardon Sheriff Arpaio of contempt and to take away the court's ability to enforce its orders for the reasons I've laid out in my testimony and that are in briefing in that case. That violates our system of separation of powers and the core constitutional command that when people's rights are violated, they can go to courts and courts can provide a remedy and protect the Constitution. So that's one. If I have time, I'll.
You can answer the finish up, and then we'll move on.
So, I think there's been a lot of reporting about potential dangled or discussed pardons where people around the president, his lawyers, have been talking with subjects of investigations about maybe there will be a pardon for you. This is just news reporting. I don't know all of the facts of this. But if, in fact, the president and his people are offering or dangling pardons to influence witness testimony in order to interfere with an investigation, that would be an abuse of the power. And I think we don't know all the facts there, and that's why it's so important to have real investigation and oversight and get to the bottom of what happened, some of which is alluded to in the short summary of the Mueller report and all of the findings and conclusions and evidence that the special counsel had on obstruction.
Mr. Chairman, I thank you for allowing that time extended, and I just want to say this evidences, although I was not able to pose questions to all the witnesses, it evidences the importance of this hearing. Thank you so very much. I yield back.
Thank you, and Ms. Barbara Jordan would be proud of you. Ms. Dean, you're recognized.
Thank you, Mr. Chairman. I appreciate the chance to be here, and thank you to all the witnesses. Thank you, Mr. Chairman, for having this hearing. Over the course of the last 2 years, I've found myself thinking I'm looking in a mirror upside down. So many things seem upended. So many things seem out of place. So many of our institutions or the use of our institutions seem just out of kilter. Much of this before I came to Congress and was sworn in January the 3rd. So maybe, I want to ask about pardon power, and like my colleagues and like all of you, talk about the importance of full transparency of the Mueller report, because if we don't have full transparency of the Mueller report and then pardons flow from the activities of that, even more troubling and more hidden and obscure will the truth be from the American public. So maybe, Professor Ken, I wanted to give you an opportunity to, and I apologize, I was in another hearing, so if this is repetitive, I'm sorry, Mr. Chairman. I wanted to give you a chance to comment on constitutional authority to pardon, and I saw your outline of the 4 kind of fundamental questions that you asked. Could you tell me some of your concerns with this president and his already use of the pardon power, and what you worry about as possible use of the pardon power moving forward?
Yes, thank you, Congresswoman. Certainly one thing that I and I think a lot of other people worry about would be, a self-pardon, but, we've talked about that at length and reasons why it seems that we all agree that that would be unconstitutional. I think also extremely troubling are, what Mr. Florence and others have referred to, the news reports, and again, we don't know all the facts, but the reports that people who seem to be intermediaries of the president have been interacting with lawyers for people who may have damaging testimony about the president to raise the possibility of pardons. And, again, we certainly would want to gather all of the facts before making any kind of conclusions about it. But I, in addition to thinking that the Congress has oversight power to look into this, those clearly could be federal crimes. Those could be crimes of obstruction of justice or related crimes. And I think we should all hope that we live in a country where the Justice Department would be independent enough to be looking into that as well.
Okay, thank you. Ms. Fredersen, one of the more troubling aspects I found with Attorney General Barr's scant summary, and it was by no means encompassing, we didn't even see a single full sentence from the Mueller report, which I found troubling. The Attorney General came to a legal conclusion regarding obstruction of justice. It was 48 hours after the report was delivered, and yet unable to deliver the report to us. He was able to get through it in that 48 hours and made the legal conclusion that there was no obstruction of justice by this president. That I found particularly troubling. The Attorney General argued there that the president cannot commit obstruction of justice. This was in his 19-page memo that he wrote before he earned the position of Attorney General, that he cannot commit obstruction of justice when using his own constitutional authority. I found that reasoning to be flawed. Could you expand on this notion of constitutional powers that cannot lead to obstruction of justice, and explain where the Attorney General's reasoning is either right or falls short when it relates to pardon power.
Thank you for that question. The issue is, as Professor Kent had discussed earlier, the unitary executive theory, which posits that the president has absolute control over the entire executive branch, and that's in all decisions, hiring and firing, and so forth, and that by exercising his discretionary powers, he can actually not commit obstruction of justice. It's a very, very questionable fringe theory, and Professor Kent and his, I think, upcoming Harvard Law Review article with a couple of other esteemed scholars goes to examine the history of the pardon power and discusses at length the unitary executive theory. It is, as I said, a fringe theory that arrogates complete power to the president that I think certainly, if you consider why there was a founding of the United States of America after a rebellion against an absolute monarch, it's clear that even if you believe in the originalist understanding of the Constitution, you would particularly then assume that the president could not be above the law. But I think maybe I should turn it over to Professor Kent, who has delved so deeply into the history that he might offer you more.
Thank you. Mr. Kent, did you want to add to that?
No, I agree that the very, I'd call it extreme, view of presidential unaccountability that was offered by Mr. Barr while he was still a private citizen has very little basis in our constitutional history and tradition. The president has many powers that are in Article 2, and the idea that just simply because you can point to some part of Article 2 and say I'm exercising that power, that immunizes presidential action from accountability by the law, it's illogical and just contrary to so much Supreme Court precedent and so many generally accepted legal understandings. I'm not quite sure what more to say about it. It's just it's incorrect.
I appreciate that, and I appreciate the chance to remind the American public of our history and where the pardon power came from, that it was to be exercised as a benevolent power, not a power to get cronies off for doing some criminal acts.
Thank you, Ms. Dean.
Gentleman to yield.
Yes.
Could I?
Well, if you go ahead.
Well, I promise it'll be brief. A concluding question along this point.
Go ahead.
But I just want to know, certainly when we all read Attorney General Barr's, or then lawyer Barr's memorandum asserting that the Attorney General the president could not obstruct justice within the meaning of the law, that this was an extreme and eccentric kind of view. Could somebody characterize whether it's gained traction in the scholarly literature or in the law generally? Is it still a real minority view, or is he speaking for a lot of people now? I yield back to you, Mr. Chair.
I'd be happy to offer an observation here. Even before that memo came out, when others in the president's circle had floated this theory, my organization, Protect Democracy, organized a letter from dozens of constitutional law scholars, I believe Professor Kent and his co-authors among them, explaining why this theory has no basis in the Constitution. What I think is important for this committee to do is to make sure that this stays a fringe position and doesn't somehow make its way into the law. Since Watergate, it's been clear that the president can't abuse his powers to place himself above the law. This president, I think, is trying to do that in a number of ways, and it is really critical for this body to make sure that that doesn't happen, and frankly, for all of the people who you represent, to make sure that we stay a nation of laws and not a nation where we have a king who can do what he wishes subject to no law.
Thank you. Let me ask y'all to refresh my recollection or to give me some information. I believe that we've only had one other special counsel, and that was Mr. Danforth in Waco under the regulations. And we had two independent counsels, Mr. Jaworski, he was a successor to another independent counsel, and Mr. Starr. Did any of those three individuals give opinions of violations of the law in their reports, or do they make the reports, submit them to Congress, and let Congress make decisions? Mr. Florence?
They made sure that those reports could get to Congress, and one thing that we've done to make sure that that's publicly known is to unearth the Jaworski roadmap that the grand jury provided to this committee in the context of that investigation, because it is so important for Congress as a co-equal branch to uphold our Constitution and ensure accountability here.
And same thing for Kenneth Starr. He didn't recommend this is a violation, that's a violation, I would indict or I wouldn't indict. He just gave the report to Congress, did he not? So this is really strange. It's the first time in maybe the history of the country in a special counsel or independent counsel that the Attorney General has jumped in the breach and given his opinion of what the report said. It's never happened. Okay, let me ask you this. Is it possible that there was a counterintelligence portion to the Mueller investigation, and that wouldn't have been part of conspiracy, but something in there about counterintelligence that might have shown that the president was compromised by his holdings of properties in foreign countries, or his desire to have a property in a foreign country, or loans that were made to him, or monies that were laundered through a bank to him, and that possibly those compromised him, and we could have a president that the report could show is under the influence or could be under the influence of the Russians, and yet it still wouldn't amount to a conspiracy? Is that not possible? Ms. Fredersen, would that be something you think might be in the, could be in the Mueller report?
Well, it might be. Obviously, I haven't seen the Mueller report, and there may be parts of it that involve national intelligence that I would never see. It's my top secret clearance has expired. But certainly an important question, and again, a reason why Congress needs to get that report, because you can certainly examine all of that.
And is it possible that there's something in there that might amount to a cover-up of knowledge of what the Russians were doing, which would not amount to a conspiracy? Like if the Trump children, or one of the children, knew that the Trump campaign was, that what the Russians were doing, but didn't say, we're going to do this for it, there's no quid pro quo, but they knew about it, and maybe they even discussed, well, we'd sure like to have sanctions lifted at some time. That wouldn't be a conspiracy, would it? How far would they have to go to make that a conspiracy? And maybe they wouldn't want it to be known if it was less than a conspiracy, but maybe a cover-up of some information.
I really don't. I can't comment on what might be in the national intelligence portion of the Mueller memo. But again, I can only say that that's why it's so vital that this body examine that information. There certainly are many aspects of certainly much that we've seen reported about relationships that have to do with financial holdings, with property, with the Trump Tower in Moscow, with a variety of other issues that may not have been part of a conspiracy, may not have been the government necessarily, but may be a reason why there could have been a cover-up. But again, I can't really speculate, but I think it's important for you, because many people are thinking of those, asking those questions of themselves, that for them to be definitively answered, it comes to Congress to do that.
You made a point in your opening statement to say that the Barr 19-page memo was devoid of legal support, right? But if it had a lot of political support, wouldn't that trump the legal support?
Right. Well, I think Professor Kent, he used the word extreme. I used the word in my oral testimony just now of fringe, but I think you can find a few people who will endorse it, but it's certainly, it's a very interesting contrast between some of the things that Mr. Barr said in his testimony before the Senate Judiciary Committee to what he said in the memo when he was a private citizen, auditioning for a different kind of job with the president. So certainly it has some political force behind it.
Coming back to pardons to close this hearing out, there was a governor of Tennessee, I don't know if any of y'all have heard of him, Leonard Ray Blanton. Anybody heard of Leonard Ray Blanton? Former member of the House, governor of Tennessee from 1974 when he was elected, leaving Congress after 8 years, and served from 75 5 to 79. Leonard Ray Blanton, at the last minute, right before he was leaving office, the FBI found out he was going to issue a lot of pardons to a lot of people for money. So, the Lieutenant Governor of the state, John Wilder, the Speaker of the state, Deborah Corder, jumped into action with the winner of the 1978 election, now United States Senator Lamar Alexander, and swore him into office about 48 hours or 24 hours, right at the last minute early, so that Governor Blanton couldn't issue those pardons, and he didn't, and Senator Alexander became, then Mr. Alexander became Governor Alexander. But by issuing pardons at the last minute, but for somebody having knowledge of it and stepping into the breach, there is no remedy. Impeachment is not a remedy. So I find Mr. Mason's perspective better than Mr. Madison's, because Mr. Madison was wrong to say impeachment is the answer. Impeachment's tough. And impeachment can't do anything for somebody who issues pardons at the last minute. And I don't, I just remember the Clinton administration, almost all the pardons were at the last minute. Obama, as I've said, I urged President Obama for 3 or 4 years to be issuing commutations. And I had confirmation from people who were in the office, his attorneys in the office who worked on that, that they had gone so slow, and the process was terribly slow, and they didn't get the offices geared up, and they lost people. They lost their pardon attorney, I think, quit. And I forget the lady's name that worked over there in the White House counsel's office. But if he issued 1,700 commutations, I again say that was about 7,000 too few. And it was 0.3, not 3%, but 0.3% that Mr. Johnson said had violated some portion of the law, 4 people out of 1,700. Obama did pretty good in his thorough examination. He didn't do good enough for the rest of them. I think we need to amend the pardon power. I recommended it back in 1977 when I was a Constitutional Convention of Tennessee vice president, or the vice president of the Constitutional Convention, and we had the pardon power before us because I knew what Ray Blanton was doing, and it had come up, and recommended that we change the pardon power and give it, say, if 4 of 5 of our Supreme Court justices looked at it and didn't think it was in the interest of justice, it wouldn't go into effect. Now, the justices didn't want to touch it, and it didn't get anywhere, but it was a way to put some kind of a limit on the governor's pardon power by having the court look at it. Here, we proposed limiting it to certain close folk. But there should be something, and I hope you all would give it a little thought and submit to me, if you would, any thoughts you have on how we should amend the pardon power or recommend it. Not easy, but there are certain things we can work together on the Republican side. We had a hearing on the Emergency Powers Act, and we have a lot of agreement there on a possible statute. And the Republicans are just as much concerned about an overreaching executive, if it's a, maybe a different party, but in general, their philosophy is that. And so we might find some common ground. I hope you'd help us with that. I'm concerned what could happen with these pardons. I think somebody said that these acts of obstruction of justice were in clear public view. That's what maybe Muller said. They were all in public view, which would have been the Comey thing. And but it wasn't all in public view because the dinner wasn't in public view when he had the one-on-one dinner and asked him to lay off of Mr. Flynn. We don't know what else was not in public view. It was in public view, I guess, when he told Lester Holt, I did it because of the Russia thing. But this president is a president who thinks he can get away with shooting somebody on Fifth Avenue. If he thinks he can get away with shooting somebody on Fifth Avenue, he's not going to have a problem in public view going, I did this because of the Russia thing. He also doesn't think about the ramifications of his actions because he's not real good on the second and third steps. Not real good on that. So I think the pardon power is something we need to look at. I think it can be abused. I think it will be abused. And the whole idea, and I'm so happy that Ms. Johnson got out of jail, my constituent, and a gentleman in Nashville got out. But there are thousands and thousands of people who Kim Kardashian has not taken to her heart, and that Sylvester Stallone hasn't read about, people who may not be dandies, who deserve commutations. And the idea that we give them on celebrity, and that he's asked for a list of people who are celebrities, not asked for people who have been unjustly convicted or served too long. He hadn't even thought about that. He's just looking for celebrities. So it's a problem. Mr. Raskin, you want to follow up with something? Professor Raskin.
Mr. Chairman, I want to thank you for calling this hearing, and I thank everybody for their flexibility and suppleness in dealing with the questions today. Obviously, we are in the middle of an ongoing constitutional emergency here, and we appreciate all of the support and the insight of the people in academia. Thank you, Mr. Chairman. I yield back to you.
Thank you, and that will conclude our hearing. And I have to find the last things I need to say. That concludes. We appreciate that. We've done that. We've done that. We've done that. This concludes today's hearing. I want to thank all of our witnesses for appearing today, even if they weren't under oral God's witnessed oath. Without objection, all members have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. With that excellent hearing, thank you for your participation. Excellent children and attendance. We're adjourned.